Afternoon. Good afternoon, everybody. I'm Erica Berg. I'm the Vice Chair of the State Bar of Georgia's Dispute Resolution Section. Thank you so much for joining us this afternoon for what we've deemed Arbitration Masterclass. We're really excited to be joined with some of the greatest lawyers in Atlanta dealing with arbitration, as well as our folks from the AAA. So it is going to be a great program this afternoon. We're split up into 3 sections. We're going to start with Shelby Gilbert and his team on recent trends in international arbitration. Shelby is a partner in the Atlanta office of McGuire Woods, where he represents businesses, manufacturers, and financial institutions in cross-border litigation, international arbitration, and complex insurance coverage. He's joined by Rebecca Lunsford-Kolb. She is an attorney with a litigation boutique, Counsel Gunneman and Challey. She has substantial experience both as an advocate in arbitration as well as presenting on domestic and international arbitration issues. She served on the executive committee of the Atlanta International Arbitration Society for the past 7 years. And we also have with us David Gallo. David is an associate with Crevelin and Forst here in Atlanta. David's practice includes commercial litigation and alternative dispute resolution. He is well-versed in these issues, and we're very excited to hear from the 3 of them. As you get started, it may be the easiest thing for you to do. We'll turn off our video. You can pin the speaker video or choose speaker view as you follow along. And I know that Rebecca, David, and Shelby have slides to share with us today as well.
Well,
turn it over to you.
Well, Erica, thanks very much for inviting us to speak today on international arbitration. I am Shelby Gilbert, and I wanted to talk a little bit about international arbitration, some trends that we're starting to see in the state and also in our practices across borders. I think it's no surprise why we're talking about international arbitration with the dispute resolution section. We've got the world's busiest airport in Atlanta. We've got the deepening of the port down in Savannah and a huge growth in international trade and investment that has continued unabated in the state of Georgia since the COVID-19 pandemic commenced. So it's really no surprise when folks say that Georgia really is one of the leading international venues for international dispute resolution and international arbitration. So we're excited to talk about it today, and we're also excited to be part of the dispute resolution section's reboot. I think today we want to talk about a couple things. We first want to talk about some trends that we're seeing in the case law. There have been some recent decisions, one by the 11th Circuit Court of Appeals that we've been watching, another that was issued by the U.S. Supreme Court today that I think all practitioners in this space should be aware of. And David's going to talk a little bit about some of those cases later. We're also going to talk about what we're seeing in our practices these days. What does international arbitration look like, not only because of the pandemic, but what types of trends are we seeing in international arbitral institutions and the rules that we're all practicing under? And Rebecca's going to talk about some of those rule changes that we are all dealing with. And then I think we also will talk about some of the fallout that we're seeing from the pandemic and what that means from our practice, for all of our practices. So we want this to be interactive. So I think there's a chat screen. So if folks have questions as we're going, but feel free to send the questions to the chat and we'll get started. So before we jump into some of the trends, I thought we ought to talk just very briefly about what is international arbitration and why are we talking about international arbitration on a panel separately from all the other panels on domestic arbitration. I think that we all know that arbitration is a process whereby parties choose to resolve their disputes through a private arbitrator rather than going to court. And that's really the same in international arbitration. But there are different rules and practices that I think folks that have practiced in this area know fairly well. But I think it's good refresher to just set the stage for some of the other topics we'll be discussing, if we could, since there are folks with varying degrees of background in this area. So at bottom, international arbitration is an arbitration between citizens or businesses of 2 different countries. I think that most people would agree with that definition. But I think that international arbitration doesn't have to necessarily involve parties from 2 different countries. It could be international arbitration involves citizens on both sides of the V, a claimant from the U.S. and a respondent from the U.S., where they're arbitrating over property located abroad, or a contract that was supposed to be performed in another country, or under the Federal Arbitration Act, a dispute that has some other reasonable relation with one or more foreign states. And these are some of the definitions from the FAA Chapter 2 that define what an international arbitration is. We also have in Georgia, the Georgia International Arbitration Code that applies to international arbitration, and it also has a similar definition for what it is that makes an arbitration an international arbitration as opposed to a domestic arbitration. Now, why does this matter? Why do we care if arbitration is domestic or international? Well, I think that the Georgia Supreme Court has had to wrestle with this recently because there are different rules that apply and different statutory regimes that apply to arbitrations if they're a domestic arbitration or an international arbitration. And some of these issues were touched upon by the Georgia Supreme Court's motorsports decision earlier this year. But the first starting point is that under the Federal Arbitration Act, most international arbitrations all are governed by Chapter 2 of the FAA, but there is a Chapter 1 of the Federal Arbitration Act that applies to domestic arbitrations, and there's a Chapter 2 that applies to international arbitrations. There's also a Chapter 3 we won't talk about as much today that also applies to certain international arbitrations. And we have a similar structure in the Georgia Arbitration Code. For those who have studied it, Part 1 deals exclusively with domestic arbitrations, and Part 2 deals with international arbitrations. And that's important because when parties need to go to court to get assistance and aid of an international arbitration, you need to know which section of these statutes to apply for. And it becomes even more important when it comes to how do you enforce an arbitration award. I think we've got well-worn.
And I'll chime in very quickly, Shelby, on you.
Sure.
One of the big distinctions in the Georgia Code between the domestic and international is the international does not codify manifest disregard. Whereas I think probably everyone in the audience here knows that in the domestic code, it is one of the, if not the only state that codifies manifest disregard. So if you're under an international, the international part of it, it's not going to be in there. It's not going to have manifest disregard as a clear grounds for vacating an award.
And that's very important and was intentional because I think that when the statute was adopted back passed in 2013, I think what Georgia wanted to do was to signal that it was open to international arbitrations and that courts would not interfere with arbitration awards and find reasons to vacate them other than those grounds that are set out in what we call the New York Convention or the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which is really the treaty that allows and has allowed international commercial arbitration to flourish and grow as much as it has over the last 60 years. That treaty was passed in 1958. I think most countries in the world are parties to this convention. There are about 30 countries that have not signed it. So if you're not sure and you're arbitrating with a country, it's always good to check and make sure that they are a party to the New York Convention, because that allows you an easy mechanism to enforce the arbitration award if the counterparty is also a party to the New York Convention. But the New York Convention is incorporated into Chapter 2 of the Federal Arbitration Act. It's parts of it are very similar to what you'll see in Part 2 of the Georgia International Arbitration Code. And one thing that's very important is Article 5 of the New York Convention, which provides, I think, as Rebecca was alluding to, very limited grounds for judicial review of international arbitration awards. So that's really the most important treaty to be aware of if you're dealing with international arbitration, because those rules will apply if you're representing a party in the United States and against another party. That's how you will seek aid and assistance of arbitration, and that's how you will enforce the award if you're operating in federal court. Now, we've also have the Panama Convention for certain disputes in the Western Hemisphere. We have what's called ICSID, which is a separate convention that deals with how to resolve international disputes arising out of investments in certain parts of the world, in certain countries. And there are over 150 countries or parties to that convention. And then there are also bilateral investment treaties, which provide another mechanism for when, let's say, the United States makes certain investments in another country to which the other country is a party to the bilateral investment treaty, that there may be other mechanisms for arbitrating a dispute. But these are all important because they ensure that if you have an arbitration award, you can enforce it at the end of the day. Now, there are some practical differences between domestic and international arbitration in practice. And each one of these on this slide, we could probably talk about for a full half-day seminar. So we're not going to do that. But I think we just wanted to flag a few of these at the outset, because I think they'll also help set the stage for some of the things that David's going to be talking about with the case law. But there's less discovery in international arbitration is the practice. It's not international arbitration is not notice pleading. It's not a practice where you can send voluminous document requests to the other side. That generally is not the way international arbitration works. And part of the reason for that is that the United States, we're used to that. People halfway around the world that are engaged in international arbitration may not be used to voluminous document discovery. Witness preparation can be very different. I think we're all used to preparing our witnesses before a hearing, spending a half day, sometimes a week with the witness to get them ready to testify at the hearing. In some countries, that's considered a violation of ethical duties under local bars. So there are different rules and different practices for preparing witnesses. Same goes for direct and cross-examination at arbitration, international arbitration hearings. I know that we're all used to the cross-examination being the crucible through which the wheat is separated from the chaff at the hearing. And that's the highlight of the arbitration. But in some parts of the world, that's really not the case. So there are lots of practices that have developed. So there are the compromises on that make sure that people from other parts of the world can find a way to get this done. And the same goes for how do you select the arbitrator? What's the role of the arbitrator? Is the arbitrator supposed to ask the questions and do more of an inquisitorial model? Does the arbitrator retain the experts for the tribunal? All sorts of different ways that this can be done. And this is also set forth in a lot of the rules that are set up that different arbitral institutions have adopted. And you really see this with the proliferation of all sorts of different international arbitration rules and institutions that are out there that parties can select when deciding which rules they want to apply to their disputes. So in the same way that with a domestic arbitration, parties can select, for example, the AAA or JAMS or any number of domestic arbitral institutions to resolve their disputes. There are many other international arbitration institutions that set their own rules. The ICC, and based in Paris, is I think we have some slides on this, is the leading institution and is used the most, but a lot of folks use these other institutions around the world, and it's up to the parties to decide which of those rules they want to use when they set out their international arbitration agreement. And the last thing I'll comment on before I pass it over to David is that it's been fun for me to develop this practice in Atlanta because the law in the 11th Circuit and in Georgia is more pro-arbitration than it is in virtually the rest of the United States. And that's one feature that we like to talk about when we're talking to our clients about why does it make sense to arbitrate your dispute in Atlanta as opposed to New York, for example, or elsewhere in the world. We've got these two decisions on the screen that I'll just highlight. The industrial risk insurers case, which is a very pro-arbitration decision and has also reaffirmed the principle that an international arbitration award is subject to being vacated only on the grounds set forth in Article 5 of the New York Convention. And that is a slightly different rule from what is set out in other circuits around the United States. And the 11th Circuit has also done away with manifest disregard as a permissible ground for vacating an international arbitration award, at least in the 11th Circuit. And these are things that we brag about quite a bit. Now, David's going to comment on the industrial risk case because just last month, not to steal his thunder, but the 11th Circuit issued a decision in the Corporación AIC versus Hydroelectrica case. And it was a decision by Judge Joe Flatt, who said that he was constrained to follow the rule as set out in the industrial risk insurers case, but suggested and invited the court to take up some of those issues on Bach because he thought that the 11th Circuit may be an outlier in some respects. So it'll be interesting to see how that develops. And as I mentioned earlier, there also was a U.S. Supreme Court decision in international arbitration yesterday, and you don't normally see that every year, but it decided some important issues under what we call Section 1782, which is a mechanism that some of you may have used to apply to district courts in the 11th Circuit to seek orders to direct the certain parties to produce documents or evidence for use in an international arbitration proceeding to get certain types of discovery that are not always available under international arbitration rules. And I think David's going to comment on what the Supreme Court said about 1782. There had been a circuit split. The 11th Circuit was on one side of it, and courts elsewhere were on the other side. And the Supreme Court has now resolved that. So I'll let David talk about that. But David, I'm going to pass it to you. I know you've got want to talk a little bit more detail about procedural law and party autonomy, and then really get into the details on some of these cases that I previewed.
Well, thank you, Shelby. A very helpful introduction that I think covers a lot of important ground for the areas that I'm going to dive into. Again, my name is David Gallo. I'm an attorney here in Atlanta at the firm of Crevlin and Horst. I'm a relatively recent transplant to Atlanta from New York, and it's been a wonderful transition, and I'm really happy to be here today talking to you guys about this kind of stuff. So, as Shelby said, I'm going to be talking about what I will call procedural law. It's a lot of those bodies of law that Shelby mentioned, the FAA, the Georgia Arbitration Code. Not every court or practitioner calls it procedural law, but I think it's a helpful term to help distinguish it from what it's not. And what it is not is, let's call the substantive law, the law that applies to the contract in your arbitration. So you could have a contract governed by Georgia law or New York law that, helps understand the allocation of rights and obligations between the buyer and the seller, or the parties. That is a different issue than procedural law, which is the law that's governing the arbitration itself, sometimes called lex arbitri because lawyers love Latin phrases. It's typically the law of the place of arbitration. If you're arbitrating in London, that the English arbitration law is going to govern parts of your arbitration. It's also the law at the place where you seek to enforce an award. So if you get an award in that London arbitration, but the assets of your adversary are in Georgia, you're going to have to come here, and certain aspects of federal or state law are going to apply to whether the court is going to be willing to enforce that award. So as we've discussed, what does procedural law govern? Existence and enforceability of arbitration agreements, validity and enforceability of arbitration awards, and other things like the availability of court assistance in aid of arbitration. So we said it's not the substantive law that's applicable to the contract, although they can be the same. You can have Georgia law apply to the contract and Georgia law apply to the procedure of the arbitration. It's also not the rules, let's say JAMS rules, ICC rules that apply to your arbitration. That might seem like a common sense distinction, but courts have struggled with that sometimes and sort of seen procedural law and the rules as somehow mutually exclusive or not understanding how they work together. So since this is recent trends in international arbitration, I'm going to talk about some recent cases that struggle with or describe or address these procedural law issues. Before I do that, I want to tell you what I think sort of the major takeaways are. One, this is not a settled area of law. A lot of things that might seem common sense to practitioners are in flux. There will continue to be litigation about arbitration in the courts, I think, for a long time. Two, this issue is often overlooked by practitioners, I believe, until it's too late. I think having a strong grasp of the procedural law that's going to apply to your international arbitration or your domestic arbitration it's best to have that understanding at the contract drafting stage and at the stage in which, a dispute has arisen, and, to reduce uncertainty and hopefully reduce litigation about arbitration so that you can get to the important stuff like enforcing awards or enforcing arbitration agreements. The third takeaway is that just as parties and counsel have control over many aspects of their arbitration, you have some control here when it comes to procedural law. It's not unlimited, but you do have some control. So let's go to the next slide, please, Shelby. So Shelby covered this, so I won't spend too much time on it, but procedural arbitration laws in the US and in Georgia include the Federal Arbitration Act, Chapter 1 for domestic arbitrations, maybe. Chapter 2 for international arbitrations, and that incorporates the New York Convention, to which 169 countries are a party. And we have state arbitration laws like Shelby talked about, the Georgia Arbitration Code, and also the Georgia International Arbitration Code. So which one of those, or one or more of those bodies of law, is going to apply to your litigation, your international arbitration? The answer is not easy. And as Shelby discussed, it really matters because they're not the same. They overlap significantly, but they are not the same. And depending on your factual issue, it can be the difference between an award being enforced or not being enforced, such as the case when manifest disregard is in play and the court's not sure whether to apply the Georgia Arbitration Code or something else. So it really matters, and courts are continuing to struggle with knowing exactly what applies and how it applies. There will be many cases where it's not a difficult question, but recent cases in the 11th Circuit and the Georgia Supreme Court illustrate when it maybe can be a little bit more difficult. So there was a case in April called Gulfstream out of the 11th Circuit, and the court acknowledged that in this case between parties from different countries, that federal law would apply by default. But the court examined whether the parties in their contract had chosen to apply Georgia procedural law to their arbitration. The court determined ultimately that based on the wording of the contract, the parties had not chosen to apply Georgia procedural law instead of or alongside federal procedural law. But notably, the court's analysis in Gulfstream did not mention at all the Georgia International Arbitration Code, which by statute would have been the applicable part of Georgia law that should have applied if the court had determined that the parties indeed wanted Georgia procedural law to apply. So I think this case tells us two things. One, which I'll talk a little bit more about in a minute, parties have some autonomy here, or at least courts believe they do, and that's probably all that matters. And two, that not all courts are completely aware of the Georgia International Arbitration Code, which is relatively new, but is very much a part of Georgia law. And I think as practitioners, we have a role in educating the courts on these things. And I suspect the court maybe was not aware of that in the Gulfstream case.
And David, if I can pop in on you, I have to tout Shelby on, the Atlanta International Arbitration Society is an organization that Shelby currently serves as the president of, but he was a large part in the lobbying efforts of getting most recently an international mediation code through the Georgia legislature. And it was Atlas's efforts that did help push the Georgia International Arbitration Code through the legislature, as David mentioned, fairly recently. And so that probably adds to the confusion that he's talking about. But I had to do a quick Atlas and Shelby plug on that one.
Absolutely. I don't think Shelby would
it's not just a Shelby effort, but to be fair, it's a Atlas effort, but also a dispute resolution section. And many folks put that together, but we're really proud of the support of the bar that has been behind all of these legislative efforts to get the 2013 code enacted, and with the help of Professor Doug Yarn and many others. And then also with our recent Mediation Act, we're thrilled about that. But thanks.
And I will say, as a relatively recent transplant, finding Atlas was a wonderful thing. Met Shelby, met Rebecca, and found folks as enthusiastic about these topics as I am. And it's a great organization, and I highly recommend it to anyone out there who's interested in these issues. The Adventure Motorsports case, which Shelby also mentioned, had something of a similar issue in that the Georgia Supreme Court looked at the enforceability of an arbitration award under the Georgia Arbitration Code, not the International Arbitration Code, but the domestic one, never once mentioning the Georgia International Arbitration Code. And in that case, they had received an excellent and crystal clear amicus brief alerting the Supreme Court to the existence of the International Arbitration Code. And the court resolved the case in a factual way that didn't ultimately create a lot of tension with the existence and the differences between the Georgia Arbitration Code and the International Arbitration Code. So that's good. But you'd hope that once alerted to the existence of the International Arbitration Code and its applicability sort of by statute, we hope that will start factoring into more decisions expressly. So it's still in flux. The other case that Shelby mentioned, and this is the one that could portend a change in 11th Circuit law in the future, specifically maybe overturning industrial risk, is the Corporación AIC case. 2 weeks ago or so, the 11th Circuit issued a 56-page opinion devoted to the idea of when you are challenging an award or seeking to enforce award under Chapter 2 of the FAA, which incorporates the New York Convention and those limited grounds for challenging, does that challenge invoke or pull in or encompass domestic law of the enforcing country? Specifically here, that would be Chapter 1 of the FAA. And the industrial risk opinion, as I understand it, basically said it's just limited to the 7 grounds in the New York Convention. What Judge Troflat said in his majority opinion in Corporación AIC was that the 5th ground under the New York Convention directs courts to pull in the domestic law, in this case, Chapter 1 of the FAA. And then there's in my opinion, beautiful 46-page concurrence by Judge Jordan that comes to the same conclusion, but I think in a way that is a better way forward for the 11th Circuit that will, I think, limit, if they go that direction, it will limit it just to the Chapter 1 of the FAA. I would be concerned that Judge Troflat's approach would actually open the floodgates potentially to bringing in all sorts of domestic law and potentially undermining the 11th Circuit's well-earned place as a predictable and sophisticated jurisdiction for international arbitration.
And what David is talking about is actually a big shift for the 11th Circuit if it does happen. It has been a long touted benefit that the 11th Circuit is explicitly limited to the international grounds for vacator. And it's actually something that we often cite for comfort for international, for who would be the advocates or the parties in international arbitration. You can find comfort in the 11th Circuit. You're not going to get a bunch of, other US domestic law that can be very confusing or discordant in this circuit. And so this is a big deal that David's talking about.
It's a big deal. Yep. And I'm sure that if this gets picked up en banc, folks will write a passionate amicus brief, and we'll do our best to help them cabinet in the best way possible. But so where does this leave us? I think the takeaway, as I said earlier, is that these issues are in flux. What applies? How does it apply? How much of it applies is not as predictable as we might think it should be. And although I think our jurisdiction is clearly pro-arbitration and more so than other jurisdictions, there is real ambiguity left to be resolved. And as a result, I think practitioners and those counseling clients have an opportunity and an obligation to help reduce some of that uncertainty, reduce some of the litigation about arbitration for your clients, save them time and money. And I think that we have that power. So if you look at a 1989 case from the Supreme Court called Volt, the Supreme Court held that parties do have autonomy in selecting the procedural laws that will apply to their arbitration. And this is not necessarily an international or domestic opinion. I think it sort of reads broadly. The US Supreme Court affirmed a California Supreme Court determination that the parties wanted the California Arbitration Code to apply to their arbitration. And the US Supreme Court said that's okay, the parties can do that, and quote, parties to an arbitration agreement should be at liberty to choose the terms under which they will arbitrate. So that's a fairly broad grant of party autonomy, which is in line with the fundamental, pillar of arbitration as based on consent and party autonomy. If we go to the next slide, we see that 19 years later, the Supreme Court reined that in a little bit as it pertains to challenging arbitration awards. In Hall Street, they said that parties may not agree in their contract to, in a sense, add grounds for challenging an award in an arbitration governed by the FAA. But they did say that the parties can, in their contract, select a state's laws, Georgia law, California law, and if those laws expand the basis for challenging an award, the court will uphold that. I'm not positive I understand sort of the logic there, but that's the law of the land. And so it sort of supports the idea that if parties, want to, if they prefer, let's say, Georgia law over federal law, they can try to make that happen in their arbitration. So if we go to the next slide, we see, coming back to the Gulfstream case. So the question here that I posed is how, to the extent we're allowed to have some autonomy as counsel and parties over procedural law, how do we do it? So my advice is be specific and be as specific as you can, because party autonomy really does matter to the courts. So in Gulfstream, which we talked about earlier, this was an international arbitration, and the 11th Circuit held that the party's choice of law provision in their contract, which said the contract shall be governed by the laws of the state of Georgia, was not a sufficient indication of the party's intent to apply the Georgia Arbitration Code or Georgia Procedural Law in place of the Federal Arbitration Act. They determined that the parties only meant that Georgia contract law governed their arbitration, and that in the absence of a specific choice by the parties, the Federal Arbitration Act applied because these parties were, from different countries. But the logic of Gulfstream, and I think it's explicit, is that if the parties had really wanted that to be the case for the Georgia Arbitration Code, or probably more accurately, the Georgia International Arbitration Code to apply, they could have done that. So if that is something you want, I would recommend your contract say something like, this contract shall be governed by the laws of the state of Georgia, and any arbitration shall be governed by the Georgia International Arbitration Code. That there will be no doubt you will not have a Gulfstream type situation where the courts are trying to read the tea leaves and figure out whether you want to import state procedural law. So again, the takeaway is we have some power as practitioners, as parties. The current law of the land is that you have some party autonomy, and you can reduce some uncertainty by understanding these areas of ambiguity in the law and trying to rein them in your contracts and in your submission agreements. And I encourage everyone to do that to the best of their ability. Shelby, Rebecca, any thoughts or questions or
Well, I
ideas
think
about
you've
this
still got to give
procedural
the
law?
punchline that we've all been waiting on for 1782. So are you
Yes.
waiting to transition to that, or are you wanting
Let's do it. So
to? Okay.
talk about recent trends. When we named this recent trends in international arbitration, we weren't sure whether the Supreme Court would issue their 1782 decision on time, but they did yesterday morning. As Shelby said, 1782 is a part of the US Code that allows discovery in aid of a proceeding in a foreign or international tribunal. What does that mean? That's been the question for a very long time, and there's been a circuit split, and some circuits have allowed discovery in aid of private arbitration abroad, and some circuits have read this statute to mean that it has to be a court or somehow a governmental tribunal. And yesterday, the Supreme Court, in a case called ZF Automotive, resolved the circuit split and determined that 1782 only reaches governmental or intergovernmental adjudicative bodies, and private adjudicatory bodies do not fall within 1782. The good news is we have clarity. I think there are practitioners who potentially had a robust 1782 discovery in aid of private arbitration practice who were disappointed with this decision. Already in the last 24 hours, I think there's been some really good initial reactions in scholarship, questioning some of the reasoning, and that's always going to be the case. But there's no doubt that we now do have clarity on this issue. So if you are in an international commercial arbitration abroad and there's discovery in Georgia, or there's a person who you want to testify, they live in Georgia, or there's documents here, you are no longer going to be able to invoke this provision to get the assistance of a federal district court to get that discovery. And that is what it is, and that's where we are. And very happy that decision came out in time for us to be able to discuss it with all of you. And I think at this point, I'm going to pass it over to Rebecca. So thanks again.
Thank you. And I do realize I probably did cut you off. Shelby, did you have any questions for David on procedural law for arbitration?
No questions, but I think that while there is probably some disappointment, and particularly in Atlanta about this decision, do you see any potential upside for international arbitration practitioners in light of the decision?
Well, I mean, international practitioners writ large, I think there are probably many folks based abroad whose own domestic legal systems would never allow for US style discovery, who are probably relieved to not have to potentially deal with the scope of discovery that was available under 1782, or the delays attendant to 1782 petitions and things like that. I'm sure there are many, many happy folks out there in that regard.
Yeah, and I can say that when I've talked to foreign companies about availing themselves of this procedure, the response has sometimes been, well, we should be careful what we wish for. If we're making the application here, could this be used against us? Now no longer is that the case, but I think previously it was a difficult conversation, particularly with those from companies that are located in civil law jurisdictions. I think if you go up I-85 from Atlanta up towards Spartanburg all the way to Charlotte, it just so many German companies in particular who have just struggled with this. And my expectation is that a lot of German businesses in particular may be thrilled with the outcome of this decision, but that's just my sense.
I agree.
Yeah, it can provide a lot of comfort to the foreign companies that are just not comfortable with what US discovery looks like. So to the extent, I know I've mentioned Atlas a couple times, but its primary mission is to promote Atlanta as a venue for dispute resolution. And to the extent it provides comfort to any foreign companies that the Supreme Court is reining in the extent of the US style discovery in the international arbitration context, even if it's not a direct translation to an international arbitration like that is seated in the US. It does, to the extent you're negotiating arbitration agreements or arbitration provisions on the front end, it can provide some comfort overall for those international entities to have a US venue.
Yep.
So Rebecca, why don't we shift gears a little bit? Maybe you could talk about some of the changes that you're starting to see in some of those arbitral rules that I mentioned earlier, and explain what you mean by the soft law concept.
I love that Shelby keeps us on track. By the way, my name is Rebecca Lunsford-Kolb. I am at, as Erica mentioned at the beginning, a litigation boutique that's about 2 years old now. I joined 6 months ago. It is called Counsel, Gunneman and Challey. It is now 4 of us that have left the big law practice that we were at for the entirety of our careers, and creating something fun and new. It's been fun so far. On the topic that I'm starting us on, it's the changes in international arbitration, really kind of the, the trends we've been seeing, what's been happening, and then how is this being reflected in the rules of all these arbitral institutions that Shelby put that big map of earlier, and how is it affecting the soft law that is governing international or guiding international arbitration. First off, Shelby asked, what is soft law? And that is, one of the questions that I always, anytime I'm presenting on something, I'm like, what did I wonder when I first started learning about this? And it was, what is soft law? What does that even mean? I'm hearing it everywhere at all these presentations. What even is it? And it's basically informal guidance that lots of different think tanks or bodies like the International Bar Association will put out that are trying to guide the process of international arbitration when there isn't a formal rule in place. So there's not, as Shelby went through, that underlying framework of an international arbitration, a treaty or a domestic law, or as David was going through, the actual governing arbitration and procedural law, or even the institutional rules, like in the domestic context, the AAA commercial rules. And so once you get past all of that, and you still have questions as to how something should be done, that's where this soft law comes in. So the prime example almost everyone cites are the IBA guidelines on the taking of evidence, because especially in international arbitration, where you're dealing with parties from lots of different frameworks, lots of different countries, lots of different jurisprudential frameworks, especially if you contrast civil law versus common law, there's a very big difference on how people approach evidence and how it should come in. And so the IBA guidelines on the taking of evidence have tried to provide some kind of framework under which all the parties can operate and have a cohesive approach to it. It's almost a gap filler type thing, and it's not necessarily governing, although I think the parties can contract to make it like the governing document for this arbitration. Like that's something you can do, but it's not on its face governing law. It's just something out there you can use to help fill the gaps of how we're going to approach this, and everyone can be on the same page for how it's going to be done. So that's the general concept behind what soft law is. And that's actually the second bullet on this slide, so I'll do the rules first. The rules are, and when I say IA in that slide title, I mean international arbitration. And so the domestic institution that we generally see is going to be AAA or JAMS or maybe CPR or the like. The biggest ones you're probably going to see in international arbitration, and I have a slide on this in a minute, are going to be the ICC that I cite in the bullet here, or the LCIA, or many, many others. It's alphabet soup. But those, when I want to see what's changing in international arbitration, I almost always start with what's the most recent change in the rules that I'm seeing. ICC generally is releasing new rules pretty frequently, and so I go and I look and see what are they doing, what's new, what are they trying to address. I think the biggest theme I've been seeing when I was going through it most recently was an adoption of, we're okay with virtual hearings, and we are going to make that explicit. And we are going to say an arbitrator or the parties can decide that we are going to do this virtually instead of requiring in person. And that is a big shift. I know that, you know, how we conduct virtual hearings is probably a topic that's been beaten to death. But the fact that it is being allowed under the rules explicitly is new and is important. A few other changes that I was seeing was transparency and third-party funding. I don't have this bullet pointed here, but the ICC rules are now requiring a disclosure of if there's a third-party funder involved, and I think it is oftentimes to make sure that there's not a conflict with the arbitrator. That's going to be interesting to see how it plays out and how third-party funding is impacting arbitration to begin with, and even, you know, litigation, but that's a whole nother topic for a whole nother day. On the soft law protocols that I'm seeing, it's a lot out there filling the gaps on how to do these virtual hearings. It's not mandatory. A lot of it's actually common sense, like have the camera close enough to your face where you can see everybody, but far enough away where we can make sure there's nothing in front of them on their desk that they can reference. Something else would be everyone in the room has to announce their presence, and only these people can be in the room. There's another one I saw under the SOL protocol, which was actually released before COVID. I think it was 2018 that was released. And it has very detailed technical specifications for what you're supposed to have in your, like, wherever you are having your virtual presentation made, how you have to set up the actual specifications. And I want to, I want to mention a couple of them because it's incredibly detailed. It's along the lines of, for ISDN based networks, you need to have an H320 standard umbrella recommendation for narrowband video conferencing over circuit switched networks. It gets incredibly detailed. Which,
so these are optional protocols that you can choose?
yeah.
Or...
And it's you know, basically I read it as, and this was out of SOL, so it might have been out of the culture that's a little bit more technically savvy than I personally am, but it also might be something that you could just provide to, you know, in an environment where you have tech support. You can say, this is what I need, and they have the exact details that they need to make sure that you're meeting the requirements that are going to be necessary to make sure there's a good streaming service and a good connection. And people aren't trying to take advantage of the process by, you know, oh no, we've suddenly hit something that's not going our way. We're having a bad technical connection. We need to reconvene in a minute.
Rebecca, I would add one additional protocol that I thought of that I think goes really well with these virtual hearing protocols is the Cybersecurity Protocols in international arbitration that I think is about 2 years old and was developed before COVID, but I think released right around when COVID started. But I think it could help folks who are concerned about, you know, well, if we're doing virtual hearings, how, you know, is my data safe? It's a really nice compliment.
Yeah, exactly. And that's a really, that is absolutely a complementary part of what everybody's trying to address and figuring out how to, again, fill the gaps of my camera's mirrored. So I need to make sure I'm moving my air quotation marks appropriately. But it is another piece of how to fill those gaps. And the final point on this slide is just Gary Bourne, absolutely prolific academic in international arbitration, has said, you know, he's commented on the fact that he does not see how it'll be a viable challenge to the enforceability of an award just because the hearing was held in a virtual environment. And Shelby, I think if we're ready to move on to the next slide, I'm going to talk about, this is the Queen Mary survey, a great resource for looking at trends in international arbitration. I think the practitioners in this area always get excited when it's about to be released. It's released, this is the one I'm citing as the 2021 survey, and it's the 12th empirical one, as you can see on this slide. It was based on research that was interviews, questionnaires, and the like for practitioners from October 2020 to March of 2021. And so it's in the height of COVID. but in hindsight, not even halfway through. So it's very useful information and does reflect people's impressions during COVID. And so the first slide here is just overall, we had mentioned Atlas oftentimes is trying to attract arbitrations to Atlanta. So I felt like it would be helpful to include this slide, which is, what's making venues attractive to practitioners. I think some of the more interesting ones are the fact that it's enforcement of emergency measures, like the venue being willing to enforce those. Political stability isn't really something that we have an issue with, but it does come into play oftentimes. But yeah, I think the one that I wanted to highlight here was the willingness to enforce emergency arbitration measures or interim arbitration measures.
Yeah, well, I'd highlight the one at the top, the greater support
course,
for arbitration by local courts and the judiciary. I think we've got that in spades in the 11th Circuit and in Georgia. And I think that other one, but we have that as well in the Georgia International Arbitration Court, all sorts of ways for courts in Georgia to jump in and fill the cracks of the FAA if parties want to obtain assistance and aid of an international arbitration in the state. So I think we've got a lot of these, so we always have some work to do.
Agreed. Thank you, Shelby. This is just mentioning again the arbitration institutions in international arbitration. There are so many of them, but the ones that seem to be the preferred ones are the ICC, which is based out of Paris, the SIAC is Singapore, the HKIAC is Hong Kong, which is a very interesting one right now, and we'll have to see how that develops going in the future. The LCIA, London, CTAC is China, and then the remaining ones like that, well, ICSID is for investment disputes, investment treaty disputes, something we haven't gone into very much, but it is based in the US and DC. SEC is Stockholm, ICDR is the AAA international arm, so that is US based. PCA is Permanent Court of Arbitration, that's European, and then the LMAA is the London Maritime Arbitration. So a lot of European and Far East institutions represented on this list. The next one is, I thought, very interesting because this is what are people thinking they want to do going forward as far as an in-person versus virtual format. How are we going to, what do people think they want to take with them now that we're kind of out of the mandatory virtual version? And you can see here that the biggest hesitation for virtual is still going to be in the substantive hearings, but almost half of the people are going to be willing to do a mix of in-person and virtual. So potentially allowing an expert witness to come in virtually, or someone who's in a different time zone and very, very difficult to bring to the US or wherever the arbitration is seated. Maybe allowing that, but having most of the proceedings held in person, that it's just, that one is going to be the hardest to move full virtual, but there is some receptivity to it. I also thought that the final point here, the procedural conferences and hearings, goes well with the next slide, which Shelby was getting to. And that is, what are you most willing to get rid of to lower the costs of an arbitration? And mentioned in here, you'll see it, the second one is oral hearings on procedural issues. And you also saw in the previous slide, that's the one that people are most willing to move to virtual as well. So I think people are done with procedural issues. They're tired of it. I get it. I also really liked that people were most willing to get rid of unlimited length of written submissions, because I'm all about that. If I don't get a page limit, I'm losing my mind. So I'm very.
I've heard of jurisdictional briefing in investment treaty arbitration in the 400 to 500 page range. It's unbelievable. Yeah.
It is. It can get so dense,
yeah.
Especially in these years. Oftentimes you can talk about. David's talking about sometimes. Did you say it was an exit one? Yeah, something where there's really interesting issues of public and private international law. People can write treatises on that stuff and call it a brief. And it's billions, sometimes trillions of dollars at stake in that stuff. So you can see why they would feel obligated to do so. So you're almost doing someone a favor by saying you have to tell me what matters. You can't give me everything.
That's right.
But it's also striking to me on this slide how many folks were willing to give up things that we take for granted, like cross-examination or party
And document
appointed
production.
experts, document production. I think that would be hard for me to advise a client to give up, yet at the same time, it's the parties who fashion the rules and decide how they want to conduct the proceedings. So going back to some of David's comments about how you set up the arbitration, we get to set the rules and work with the arbitrators to define the process. But it takes two to tango.
And I also really like that international arbitration can influence our approach to domestic arbitration in the US. I found that when I'm doing domestic arbitration, a lot of the things that I have been forced to accept in international arbitration when you're dealing with, for example, party from a civil law country, they can be really useful. And maybe we do cling a little too tightly as US litigators to the no stone left unturned mentality. And, fighting every single fight. Like sometimes you can truly try to get to the truth and do it in the most efficient way possible for the dispute at hand. And maybe we don't need to cling so hard to every single thing we've always done.
Yeah.
I know we're coming up short. I do have one more slide, I think. Yes. This is diversity. I know it's gotten a whole lot of attention over the past probably 5 to 10 years, especially in international arbitration. And again, I don't want to, harp on something, and I don't have time to, but it's important to keep talking about it and see where we're making progress and where we're not. And according to this survey, at least as to people's perceptions, it does appear that we're making progress in gender diversity. Over half of the respondents either agreed or strongly agreed that they're seeing progress on gender diversity in arbitrations. And this is specifically on arbitral tribunals, so people that are being appointed to arbitrators or as arbitrators. There's not necessarily a whole lot of progress in some of the other areas, though, especially in cultural and ethnic diversity. That's in the international context. You could probably pull a pretty easy parallel to the domestic context as well. You can see a few other interesting ones, geographic and age diversity. We could talk a lot about it, but we don't have time. And I just wanted to put it up there so that people could see and allow their opinions to be continually influenced.
Thank you guys so much. Does anybody have any questions? We don't have any questions yet in the Q&A box, but if somebody has one, you can put it in the chat over the Q&A. So Shelby, David, Rebecca, any parting comments?
Well, we put on the screen a lot of other resources. We know we covered a lot of ground today, but we've got a lot of materials up on the Atlas website, arbitratedAtlanta.org, and there's a great desk book compendium that we've put together that has all of the international arbitration rules and commentary. It's a great resource. I think David, since he moved down to Atlanta, started this great blog on developments in international arbitration that I'd encourage folks to look at. And also Rebecca's former partner, Andrew Flake, has got a great blog. I know there are lots of other resources out there. Would also like to put in a plug while I can for I think will be our 11th or 12th annual conference in international arbitration, which will be in September. We're looking forward to that. It's going to be a 3-day event, and we'll be getting together, barring a new turn in the pandemic, in person for the first time in 3 years. And we're really excited about that. Virtual hearings are great, but there's nothing better than getting together with like-minded professionals. So thanks for that. And don't know if any questions have come up, Erica.
No, we don't have any. This has been fascinating. You guys really appreciate the time and effort that you put into this presentation. That's why we invite you to come talk to our group. So thank you so much for joining us today. I appreciate it. So we'll make. Thank you
Yes,
so much.
thank
It's
you.
great to have you. So we'll make a quick transition to Linda BA from the AAA and Charles Dorsey. So hopefully they can get their cameras up here. This session is going to focus on what arbitrators are seeing in arbitration and how we can improve our efficiency in arbitration. Linda is the Vice President of the AAA Atlanta Regional Office, focusing on the AAA's construction, real estate, and environmental division. In that role, she interacts with the AAA's clients who file construction, real estate, or environmental cases, and the panelists who serve on those panels. It covers a 15-state territory in the South, Southeast, and Midwest. Linda also serves as the Vice President of Innovation, overseeing AAA's innovation program and innovation efforts. And Charles Dorsey oversees the regional case management in the Southeast and the Central United States for the Labor, Employment, and Elections Division. He's been with the American Arbitration Association since 2010, working closely with divisional vice presidents to promote AAA services and programs, recruitment and training of the association's rosters of arbitrators and mediators, will focus on outreach and education efforts in the Southeast and Texas areas. So we're very glad to have both Linda and Charles with us today, and I will turn it over to you.
Thank you, Erica, and good afternoon, everyone. It's a real pleasure to be here with you today and to share with you some findings from the AAA arbitrator surveys that we conduct on closed cases that go to award, and what insights can be gained from the arbitrator surveys into maximizing economy and efficiency in arbitration. So a little bit about the surveys. So as I said, the AAA sends a survey to arbitrators on cases that reach an award. And the surveys ask questions to get the arbitrators' views regarding the efficiency and cost effectiveness of the process. We ask questions about motion practice, discovery, and other efficiencies and practices that the parties engage in. So this report that we're sharing today, it's a little bit dated. It covers awards between February of 2015 and January of 2018. So we are due to gather another 3-year crop of arbitrator surveys and update this. But I think that most of the findings here would not be dramatically different, except with a few things post-COVID that I'll comment on later. But the report we're sharing today is based on responses received from arbitrators on over 400 awarded commercial cases with a claim or counterclaim of at least $1 million. So the median number of days from filing to award was 497 days, or about 1 year, 4 months on these cases. Median claim was about $2.5 million. Median arbitrator compensation was close to $32,000 for one arbitrator and $117,000 for 3 arbitrators. I would just point out that that is the difference in cost savings and speed that can be gained from going with 1 arbitrator versus 3. You can see it right here in black and white in front of you, at least on the financial savings. It's on commercial cases, it's actually cost 4 times more to have 3 arbitrators than 3 times more. So that's an area where efficiency and cost savings can be had. 54% of the cases in this report used 1 arbitrator, so that's good. More than half went with 1, and 46% used 3 arbitrators. I mean, what's interesting about that is that these cases with claims $1 million or more are typically under the commercial, large, complex commercial rules, in which case, unless the parties agree otherwise, the case would be heard by 3 arbitrators. So notwithstanding the fact that the rules would call for 3 arbitrators on these cases, more than half went forward with 1 arbitrator. So maybe we're convincing some folks along the way that, 1 arbitrator is a good choice in many cases. And specifically recorded are arbitrators' views on factors that contribute most to the escalation of time and cost in arbitration, the use of motion practice and discovery, and what best practices can improve the economy and efficiency of an arbitration. So Charles, you want to start talking to us about motion practice?
Sure. I'll start off by saying that obviously the best place or the starting point for any efficient, cost-effective arbitration is probably going to be the arbitration clause and how it's written. And then you'll hear a common theme throughout this presentation, probably about how a lot of these things can be addressed at the preliminary hearing as well. So we'll start with motion practice and the survey findings. And was the subject of motions addressed in the parties' arbitration clause? And you can see here that most of the arbitration clauses did not directly address motion practices. And there was a little variation between industries from 8% all the way to 13.6%. Which was technology at the highest. So we don't have any, Linda, I don't think we have any real correlation between these industries and why some addressed motion practices more than others, but we can see starting right out in the arbitration clause that piece is not being addressed, by and large. So next slide. And then you can see in this, how were motions addressed in arbitration clauses? So if they were addressed, motions were almost always permitted. So it wasn't like, arbitration clauses were eliminating motions altogether. And then about 20% of those clauses put some sort of restriction on them. So 1 in 5 arbitration clauses that addressed the motion practices did put some sort of restriction on the number of motions and the motion practice that will be allowed during the arbitration. Linda?
All right, so were motions of any kind filed? Over 85% of cases saw motions filed, so our advocates like their motions, and they're filing motions, and arbitrators are permitting the filing of motions. So the prevalence of motions was consistent across all segments, these industry segments that are highlighted here, with none lower than 80%. So clearly motion practice occurs in arbitration, but it is an area that arbitrators can help manage parties' expectations. So the AAA commercial arbitration rules only mention one type of motion, and that is dispositive motions in Rule 33. And the rule states the arbitrator may allow the filing of and make rulings upon a dispositive motion only if the arbitrator determines that the moving party has shown that the motion is likely to succeed and dispose of or narrow the issues in the case. So the filing of dispositive motions is clearly addressed, is permitted, but with the caveat that if the arbitrator determines that a moving party is likely to succeed to dispose of or narrow the issues in the case. So in practice, what typically happens is arbitrators have parties file a written request to file a dispositive motion before they actually prepare and file the motion itself. And in their written request, they are showing how the motion is likely to succeed or narrow the issues. In the construction industry arbitration rules, they are more explicit as to requiring a written request to file a dispositive motion. And the construction rules say, upon prior written application, the arbitrator may permit motions that dispose of all or part of the claim or narrow the issues in a case. So Charles, how about in the employment rules? What do they say about motions?
Sure, Employment Rule 27 basically says the same thing as the commercial rules state. I will say that in employment arbitration, given that employees typically are signing these arbitration agreements as a condition of employment, many arbitrators are reluctant or show some reluctance to allowing dispositive motions for the benefit of just giving the claimant the opportunity to have their day or to have their case be heard. So not all arbitrators take that stance, but there are some that do. And then there are others that allow them as well. So.
Okay, so what kinds of motions were filed? So discovery and dispositive motions were the most common, each present in over 50% of the cases. Discovery motions were the most common, and of course, discovery and discovery disputes are a big cost driver in arbitration and an area where the arbitrator can help to set the parties' expectations and limit discovery in order to ensure a more efficient and cost-effective process. So Charles and I will be discussing the survey findings on discovery in upcoming slides. So we've talked about dispositive motions, those being the second most filed, but notice that postponements are third. And postponements can significantly delay resolution of the dispute and drive up costs significantly. In fact, postponements were cited by 20% of respondents as a factor contributing to time and cost, along with discovery, motion practice, and uncooperative parties. So the AAA rules permit the arbitrator to postpone any hearing upon agreement of the parties, upon request of a party for good cause shown, or upon the arbitrator's own initiative. And that's pretty rare that we see an arbitrator postponing hearings upon their own initiative. AAA frowns on that. We try to do everything within our power to retain hearing dates, as long as the parties want to keep hearing dates. So it's very, very rare that you would ever see in a AAA arbitration, the arbitrator on their own initiative postponing hearings. So arbitrators will often include language in their scheduling orders stating that all deadlines will be strictly enforced, except with permission of the arbitrator, good cause having been shown. So we keep seeing that standard of good cause for postponing or extending deadlines, given the impact on efficiency and economy and speed in arbitration. So Charles, you want to start us off on discovery?
Sure. Did the parties' contract limit the scope or the time period for discovery? And you'll see here, again, just as with motions, discovery was rarely addressed in the parties' contract. There was some variability with industry, just as it was with motions. I think we have a clause builder tool, and I'm sure there are other tools that are out there that allow parties that are creating contracts or arbitration clauses to address discovery, giving them some options that they may want to use. I know that the employment, FLSA and employment, we have discovery protocols that the parties can agree to as a way to address and limit or make discovery more reasonable. Obviously, discovery is probably the most where costs really get, can go up and efficiency can go down. And so we're always working closely with arbitrators and so forth to try to address these issues as they come up. But again, a common theme I'll point out is that, and I think Linda mentioned it, is setting those deadlines in the preliminary hearing of the scheduling order and addressing how discovery should look during that phase is probably goes a long way to making sure that when we get to this part of the case that it's being done in an efficient manner and a cost-effective manner. I'll give you some examples of, let me say that the employment rules address discovery in Rule 9 by stating that the arbitrator can allow it as he or she feels necessary to for a full and fair exploration of the issues. And Linda, is it addressed in commercial?
Yes.
Okay, so I'll give you some examples of some arbitration clauses that kind of address discovery. Depositions is an example would be where they say depositions will be limited to a maximum of, 3 per party and shall be held within X number of days of making a request. And additional depositions may be scheduled only with the permission of the arbitrators. And for good cause shown, each deposition shall have be limited to a maximum of X amount of hours. So an effort to create some parameters right up front. And then another example would be if the dispute is less than a certain dollar amount, there'll be no discovery other than the exchange of documents and so forth. I think I wanted to point out also, commercial rules are silent necessarily as it relates to depositions, but AAA's procedures on large complex cases, which apply to larger disputes, provide for depositions at the discretion of the arbitrator in exceptional cases and upon good cause. So there's some things built into the rules as well to address it and make it more efficient on lower dollar cases. Next slide.
Right, and Charles, I just would add, yeah, and we'll get to a little bit more on the rules around discovery, the commercial rules. But if anyone's interested, the examples that Charles was giving, and there are more, you can find them at clausebuilder.org, one word, clausebuilder.org, and it sort of walks you through the various considerations for what you might want to include in your arbitration agreement. And limiting discovery in the arbitration agreement is, something that the parties may want to do. Okay.
Yep. So did the parties agree to loosen these limitations? And if discovery was addressed in their contract in slightly more than half of the cases, the parties would agree to expand discovery beyond the restrictions provided in the clause. So even when it was addressed, the parties would agree to expand it beyond that. It's kind of what the behavior has been. Linda, do you have anything to add?
Yeah, I would just simply say at least still almost 43% are adhering to what's in the contract, and having discovery limitations written into the contract. If the parties get to arbitration, if somebody wants to hold to those limitations, they're there. And if they're in the contract, the arbitrator is obligated to adhere to them. So even though we're seeing, more than half of the time the advocates are agreeing to loosen them, it's still, they have their effectiveness when someone does want to keep them.
Yeah, it's a great point. So here we have, did the parties' contract provide for extensive discovery that would be available in court? And parties overwhelmingly did not provide for litigation style discovery in their arbitration clauses. So that's good, obviously. And it also, helps to make the process more efficient as it relates to discovery. So in the commercial rules, they explicitly state that care must be taken to avoid importing procedures from court systems. I know sometimes we'll see arbitration clauses that call for the federal rules of civil procedure. And we do have a conversation with those on employment cases as to whether or not the parties are sure they want to do that. And we explain to them the difference and how that might work and how it might drive up costs versus taking a more streamlined approach. In employment, again, the rules state that it's allowed, discovery is allowed, but it has to be consistent with the expedited nature of arbitration. So our rules don't necessarily provide any, spelled out way that discovery should be addressed in terms of amount and so forth. But I think the spirit and intent and the streamlined nature and cost-effective nature of arbitration is addressed and points everybody in that direction. So.
Yeah, your comment, Charles, made me think about, when AAA amends its rules, we always have to balance. You can't be too narrow in the parameters of the rules, because it's got to be adaptable enough for the wide variety of cases that are going to use the arbitration rules. And I know sometimes I've heard arbitrators say, oh, it'd be great if if the rules had a little more teeth or were more specific on some of these points. It would make it easier for the arbitrators to point to the rule and enforce it. So that is a responsibility of arbitrators to take the spirit of the rules, as Charles just said. Again, you'll hear us say this throughout this presentation, especially when we reference the rules, but that again and again in AAA's arbitration rules, it talks about the goals of economy, fairness, and cost effectiveness. And so, that is the goal of arbitration. Those are some key points that distinguish it, at least the efficiency and economy, distinguish it from litigation. And so our arbitrators, even when parties are agreeing on certain things, it can be very challenging for arbitrators to kind of make the parties justify, why do you need that much discovery? And there are, some techniques that we'll talk about in an upcoming slide about how you can sort of, an arbitrator can, push back on the parties a little bit to say how discovery can be limited, but it is a very important responsibility of arbitrators.
Yes, and I think the parties, as you can see from this slide, I think they come to the table wanting and understanding why they're in arbitration and wanting it to be efficient, but I think it could be hard to maintain that as you get into the case and have a desire to want to, produce as much evidence as you can or present your case in such a fashion that we start moving away from cost effectiveness and efficiency. So again, I think it points back to, as Linda pointed out, where the arbitrator comes in and where setting the stage at the beginning of the case comes in as well. But at least in this slide, it shows us that not many people are asking for litigation style and extensive discovery in their arbitration clauses.
Right. Okay, so was discovery limited to document exchange? So it was limited to document exchange in less than a quarter of commercial cases. So except for energy cases, which were by far the least likely segment to limit itself to document exchange, there was very little variability at the industry level. So the AAA rules address document exchange and state that the arbitrator shall manage any necessary exchange of information among the parties. Here's this language again, with a view to achieving an efficient and economical resolution of the dispute, while at the same time promoting equality of treatment and safeguarding each party's opportunity to fairly present its claims and defenses. So that's the arbitrator's balancing act. The rule goes on to describe the arbitrator's authority with respect to document exchange, including such parameters as production of documents believed by a party seeking the documents to be relevant and material to the outcome of the disputed issues. As well, arbitrators should consider the size and complexity of the case when making decisions as to the scope or extent of document exchange. So, this concept of proportionality, what amount of discovery is proportionate to the size of the claim, the complexity of the case. So document exchange and discovery is discussed at the preliminary hearing, and the arbitrator's determination on such issues is generally included in the scheduling order. So to Charles's point about setting the stage at the beginning, that preliminary hearing is really critical, at least on AAA cases. It is the first time where the parties are getting together with the arbitrator. Usually it's by phone, but since Zoom and everyone's comfortable with video conferencing, we are seeing more preliminary hearing conferences conducted by video conference. And so that's the arbitrator's first opportunity. And actually, I take that back. It's not the arbitrator's first opportunity. In fact, and this is a best practice, is that even prior to the preliminary hearing, it's a best practice that the arbitrator ask the parties to meet and confer regarding the deadlines and the schedule that will be discussed at the preliminary hearing. And so that would include discussing whatever discovery and document exchange they anticipate, and hopefully to get the parties cooperating together and limit or avoid disputes about what documents are to be produced. Charles, is this the same for employment rules?
Yeah, absolutely. And maybe with a little twist, the actual manager of the case, when they invite the parties to the preliminary hearing call, they actually send them an outline and actually encourage them to confer and maybe even come up with a proposed scheduling order. And so we actually don't necessarily wait for the arbitrator to make that invitation. We may reach out to the arbitrator and ask while they're conferring, is there anything else you'd like for them to address outside of this outline? But the idea is still the same. We want them to try to work together prior to coming to that call, have some things already in place, some ideas, setting the stage already in place before we move forward from there.
Yeah, absolutely. And on the commercial side, commercial construction, AAA also provides an agenda or a scheduling order template for the parties to use. And then if, many arbitrators have their own preferred template, we're happy to provide that to the parties in lieu of AAA's template, but it still, accomplishes the same thing. As well, the AAA commercial rules, construction rules have an entire section, the P section for preliminary hearing, that sets forth a very extensive list of items that may be discussed at the preliminary hearing, as suitable for the given case. So as you can tell, AAA considers that a very important point of the process, setting forth the schedule and having the parties involved in that. Okay, how long was the discovery period? So it was reported that in most cases, 60% discovery was conducted or concluded by 6 months after initiation of the arbitration. So that's, seems pretty reasonable. Again, these are $1 million plus cases. And again, time limitations for discovery can be placed in the contract. Right, so what types of discovery occurred on these cases? So depositions of parties were conducted in a significant number of arbitrations, although less frequent, depositions of non-parties and experts were still a common part of discovery. And depositions and requests for documents were the most common. So the large complex case procedures of the commercial rules address depositions, and the arbitrator is granted broad authority to order and control the exchange of information, including depositions. So depositions are only explicitly mentioned in the large complex section of the rules. Commercial rule L3 states, and this is a lot of qualifying language in this rule. In exceptional cases, at the discretion of the arbitrator, upon good cause shown and consistent with the expedited nature of arbitration, all of those qualifiers, the arbitrator may order depositions to obtain the testimony of a person who may possess information determined by the arbitrator, here's another standard, to be relevant and material to the outcome of the case. And the arbitrator may allocate the cost for taking such a deposition. So, arbitrators have different views as to the necessity of depositions, the, how effective they are, should they be conducted or not. And it's up to the parties on a case-by-case basis to convince the arbitrator that for them it's an exceptional case and there's good cause for depositions to occur. All of that said, depositions are happening as reported in the surveys, 66% of the time. So back to some of the points Charles made about limiting discovery in the arbitration clause. Likewise, arbitrators may limit the number of depositions. And one tactic we see quite often is when parties are asking for depositions or what seems to be an excessive number of depositions, arbitrators may permit the parties to initially take their top 2 or 3 depots. And then after they've done that, if they feel they need more, the arbitrator says, well, come back to me and explain why you need more. And they almost never come back asking for more. So I think that's a good practice that you can try if the parties seem to be wanting an excessive number of depositions. Arbitrators may also place time limits on depositions. So it might be time limits on each deposition, or an arbitrator could set a time limit in which all depositions are to be conducted, and the parties can, use that time as they see fit. So there's a number of ways that arbitrators can manage depositions. And one other practice you might consider is limiting the depositions to the main fact witness each party intends to call, and impose costs of deposition on the parties insisting to go beyond main fact witnesses. So again, we have that balancing act of arbitrators trying to honor the spirit of the rules for efficiency and cost savings and time savings. When you have parties that are agreeing to what seems to be extensive discovery, and then the situation where the parties disagree. And I think that actually is a little easier for arbitrators to say, look, somebody's objecting to depositions or this number, and to place limitations.
So subpoenas, the parties request subpoenas for discovery. Significant variability across industries in terms of whether or not subpoenas were requested. But I guess overall, what you can tell from this slide is that at least in over half of all cases, subpoenas were requested, while only about 1/3 of our energy and healthcare cases, which again, I don't know what the correlation is there, but it could have been the amount of cases and so forth. But I think as a general rule, you can see over half. So again, in our rules, an arbitrator or other person authorized by law to subpoena witnesses or documents may do so upon the request of any party or independently. And the same goes to, and that's in our rules, I believe, across the board. Next slide. So generally, subpoenas were granted. So the question obviously to the arbitrator here is, did you grant the subpoena request? And generally, they were granted if they were requested. And a few caseloads, as you can see, are at 100%. Finance, franchise, healthcare, construction, nearly 100% subpoenas were granted. I think, Linda, we have on our website, there's a frequently asked question document that we have out at adr.org. And maybe we can share the link later, but it is it includes best practices for and answers some of your common questions that may come up about the use of subpoenas and how they can be utilized and requested and so forth. Next slide. So were you called upon to rule on discovery related disputes, whether by motion or by other means? And of course, discovery disputes were common in survey cases, and they were often cited as a factor that contributed to an increase. So again, going back to the beginning of the case and how we can be prepared, there are going to be disputes, likely. You probably know at the beginning of a case, the arbitrator and the parties, by the nature of the case, the nature of the dispute, and what's at hand, whether or not there are going to be any discovery disputes that may come up. So we have to be able to prepare for those by, setting deadlines, setting limitations, whatever it is we can do to maintain that cost and efficiency and that spirit and intent of a streamlined alternative dispute resolution process. Some practice tips: establish that the parties are to try to resolve all discovery disputes before bringing them to the arbitrator. The AAA, as we see discovery disputes come up, that maybe there's exchanges between the attorneys and so forth, we bring the arbitrator in after we've given them an opportunity to confer and determine whether or not they can make a resolution of this. Once the dispute gets to the point where it needs to be raised to the arbitrator, then we do so. But even the arbitrator may ask the parties to try to confer and see if they can resolve it. Maybe there's a quick call or something that may happen to see if we can get everyone on the same page and see if we can resolve this at that time. But again, the recommendation, just as it was at the beginning of the case, is always for the attorneys, for the parties to meet and confer before we have to initiate, or before the arbitrator has to initiate some type of procedural order or something. Any resolution or determination by the arbitrator should be confirmed in writing, obviously, as quickly as possible. And then in order to reduce the expense, the party should be made aware of other options that are available. I think I mentioned earlier that we, in employment, there are a set of, and we send these out on every case at the beginning, a set of discovery protocol that the parties can agree to in order to address these things early and maybe avoid getting into any types of disputes, because you've kind of laid the outline out and agreed to how this would go from the very beginning. Then we also have the AAA streamlined panel option, in which one arbitrator rather than a full panel may decide discovery disputes. And I'm going to let Linda tell you a little bit about that streamlined panel option.
Right. So, of course, a lot of savings can be realized just by having one arbitrator out of a panel of 3 deal with discovery disputes, sign subpoenas, for example. And so AAA, I think it's been a few years ago now, we began offering what's called our streamlined panel option, where the parties can agree that one arbitrator will handle all of the pre-hearing matters, handle the discovery disputes, sign subpoenas, deal with motions. In the case of dispositive motions, you know, the parties are able to request to have all 3 arbitrators weigh in on that. But otherwise, one arbitrator will handle all of the pre-hearing phase of the case, and then the other 2 arbitrators will join in, and all 3 will hear the merits at the evidentiary hearings. So this has proven to be a very popular option for parties. Many parties are agreeing to handle their cases this way. And typically what happens is when the arbitrators are being appointed, that's happening in the normal manner. The 3 arbitrators are getting appointed at the same time, but then it's determined who will be the chair, and the chair will go forward with the preliminary hearing, with the pre-hearing phase, and the wings will go inactive. And so they will not be spending time on any issues in the pre-hearing phase and thus billing for it. Only the chair will be doing so. Now, the exception is that the wing arbitrators, of course, throughout the pre-hearing phase, they are still responsible for making any necessary disclosures. They would be consulted, of course, on their availability for hearings. But otherwise, this has been a very effective process. The second option is that the case just gets one arbitrator appointed up front, and that the other 2 are appointed much closer to the hearings. So I do believe that the first option is utilized more often. And as a matter of fact, even though 3 arbitrators are appointed up front, if the case proceeds with the chair and the parties then wish to just go to hearing with the one arbitrator as chair arbitrator, then they can do that. So it's by party agreement, and it has been very effective.
Hey, Linda, it's Erica.
Yes.
We had one of our group ask a question, which is if most participants end up choosing one arbitrator, which is what we saw in your earlier slide, has the AAA thought about changing either the dollar amount for when 3 arbitrator panels would be done, or any other language updates to reflect most people's choices?
Yes, yes, great question. And that's something that's, been discussed over the years. And we are just about to publish newly amended commercial arbitration rules within this summer. And I do believe the threshold is getting raised to 3 million. I know that the amended rules are like in their final review. So, but my understanding is that yes, that threshold is for large complex case procedures is getting bumped up to 3 million.
And a follow-up question, do the case managers make the parties aware of the streamlined, sort of you can have one to do everything pre-hearing and 3 for the final? How's that conveyed?
Right. So, yeah, I mean, that is relying on the case manager to offer it. So I would not say that it's offered on every case that's going to have a panel. So it's good that people are here today. You're hearing about it because parties can always ask for it. But I think the case managers are typically going to be offering it. Certainly if at the initial administrative conference call that the case manager has with the parties, they discuss arbitrator selection. So if parties, we always try to encourage them to agree to go with 1 instead of 3, and that's where you saw that 56% going with 1, if it's not already written into their agreement. So as part of that discussion, sometimes it becomes obvious that maybe one party is concerned about cost, one party isn't. That would be a great opportunity to offer streamlined panel option. Or if both parties are like, yeah, we're very concerned about cost, but we would like 3 arbitrators to hear the merits. So we're usually looking for a trigger to offer that, but we do try to ask parties, would you like to agree to go with 1 instead of 3? So we're getting at it either way. We're trying to get at that, getting them to 1.
Thank
And
you.
Linda, for those that may do employment arbitration, it defaults to 1 regardless. Unless the parties agree or it's written into the arbitration agreement, it will be 1 arbitrator regardless of the dollar amount.
Great. Okay, any more on this one, Charles?
No.
Okay. All right, so the next questions deal with efficiency and cost effectiveness. And we asked the arbitrators on a scale of 1 to 5, how would you rate the complexity of the case? And so you can see overall it's at 3.84 on a 5-point scale, so pretty complex. And again, recalling that these are commercial cases with claims of at least $1 million. So you probably expect them to be a little more complex. So let's take a look at the next slide. Is going to show us what were the complicating factors. So you can see that arbitrators in over 70% of the cases cited the factual complexity as a reason why time and costs were higher than normal. And then complications related to legal issues were also very common. We see the number of claims, the amount in dispute as factors, but the last one, number of parties, we see that just over 11% rated number of parties as a complicating factor. I wanted to make the comment because I'm in AAA's construction division and handle a lot of construction cases, that if these surveys were limited to construction cases, I think number of parties would rate much higher in terms of a complicating factor. So, that's sort of unique feature of construction cases, multi-party, sometimes we have cases with 10, 20, 30 parties. It's just not uncommon due to the nature of construction projects. So certainly in the construction context, that is a complicating factor. And then of course, in those multi-party cases, you're getting number of claims. So our construction arbitrators are, that's a special challenge for them. Okay, and then on a scale of 1 to 5, how would you rate the cost effectiveness and efficiency of the case? So healthcare and technology cases were given the highest marks when it came to efficiency and cost effectiveness. And, as Charles has commented a couple of times, at this time, we don't have access into like, why healthcare and technology? I don't know that. I don't believe our survey sort of divined why those particular caseloads would have the differences in those ratings. But construction and financial services were among the lowest. And I do wonder, at least on construction, whether, again, the multi-party cases are having an effect on cost effectiveness and efficiency. They're very challenging. And I will say that, AAA and AAA's construction rules, anybody that handles construction cases, you're probably very familiar with Rule 7 that addresses consolidation and joinder. AAA, that is something that we're very focused on. Our case managers are very sensitive to trying to make joinder and consolidation issues and requests as efficient as possible. We don't want cases to get bogged down there and driving up cost and decreasing efficiency. So the AAA rules and the AAA staff, I'll tell you, AAA just had its annual construction arbitration conference in New York last week, and all of our directors from around the country attended, and we had a meeting with them the morning after. And number one on the agenda was R7, and how can we improve R7 for efficiency and cost effectiveness? And it is a topic that has been discussed, over several years, because we want to, really bring AAA's administrative expertise to that point in the process. I couldn't imagine on a non-administered case, how the arbitrator handles all of that. It would be, I'm sure arbitrators really appreciate having a case manager when those issues come up. All right, so Charles, what did the arbitrators say were the factors that led to increased cost or delayed the case?
Well, surprise, right? Discovery, motion practice are at the top of the list. And then you can see difficult and uncooperative parties would be third. I'll point out that in that other, all the way at the end, what you have that falls in that category are anything from incompetent counsel to change of counsel, late addition of claims were also mentioned as well. I think it's a best practice. Again, I'm a big advocate for focusing on that preliminary hearing at the beginning of the case. But I think it's a best practice, especially when our managers have an opportunity to get the parties or the counsel on the phone before we even do the preliminary hearing to ascertain what kind of experience with arbitration the attorneys have had. Maybe there's an attorney that hasn't done arbitration before or hasn't done it that often, but you can kind of gauge a bit and prepare the arbitrator for the preliminary hearing and kind of set the expectations in terms of based on the level of experience of those individuals that are participating in the case. So again, incompetent counsel, change of counsel, late additions to claims, those all go back to, I think we have postponements at about 20%. Those are going to contribute to postponements and delays. And then of course, we've talked about quite a bit about how we can manage discovery and motion practices in advance from the front versus from a reactive standpoint if we're able to. So there's going to be discovery, there's going to be motions, but now we need to figure out a way to address those. I think this survey was done, I think Linda pointed out, 2015 to 18 for awards that closed, and I don't think there's a lot of change at this point. Probably the last couple of years we haven't had an opportunity because of the pandemic to and like Linda said, it's time, but I'd be very interested to see how much the needle has moved in some of these areas. But we've been talking about these areas in particular for quite some time across the industry. So next slide. So in this slide, how important do you believe the parties and representatives thought it was to resolve the case in a cost-effective and expeditious manner? So it can be seen overall that the claimant side of the dispute was perceived by the arbitrators to be slightly more likely to think of the efficiency of the case as important or somewhat important. I'll point out in employment arbitration wasn't included in this survey, but one of the differences with employment is that the company or the employer pays for the cost of the entire arbitration. And so there might be a little more interest in efficiency and speed and so forth. But again, it really just depends. They also could be interested more in delaying it, and it's the claimant or the employee who wants this thing to move along fast to get to a resolution of their claim. So again, though, I think overall, it was the claimant side that perceived by the arbitrators to be slightly more likely to think of efficiency. Linda, did you have any thoughts on that from commercial perspective?
No, nothing more to add.
Okay.
Yep.
So then on the next slide, this is interesting. This is the effect of party interest on case efficiency according to the arbitrator. So you have the claimant and the claimant rep. I'm a kind of, the slide might be a little difficult to follow, but you have in the first two sets, you have the claimant and the claimant rep, and in the second two sets, you have the respondent and the respondent's rep. And I think what I see here, and what you should probably glean from it, is there's a positive relationship between the party and the actual representative in terms of the efficiency or the interest in the efficiency of the case and the effect on their ability to make the case move efficiently. So if I had a wide variation between the actual party and their rep, then we would want to. I know commercial has done some things like, and I think we all have. Sometimes we ask the arbitrator do they think it'd be a good idea to invite the party to that preliminary hearing so that they know what their attorney is doing in terms of moving the case along and focusing on efficiency and getting this thing to a quick resolution. So I have seen that happen, not as often as I think we'd like at times, but I do think that this slide at least shows us that the interest is there. And then
Charles, just one question on that. Sure. Should it be on the case managers to recommend to the arbitrators that they invite the parties to the preliminary conference? As an advocate, I always bring my client because I want the arbitrator to see my client, whether it's in person or by Zoom. But is that something that the arbitrator should be doing, the case manager should be doing, all of the above? What are your thoughts?
I think that all of the above is probably it. I mean, we don't wait for the arbitrator to suggest it. If we think it's, we suggest it as well. And we also let the arbitrator know that it's an option, maybe if they haven't considered it. And oftentimes they'll take us up on that. Or Linda, I don't know if you've ever had any pushback from the advocates.
No, and in fact, it's in the commercial and the construction rules that says that the parties should be invited along with the advocates so we do, I think our communications setting the preliminary hearing will reference that. But yeah, and you know what, all the more if the arbitrator as well is encouraging it.
Linda, how often do you see it where the parties actually do?
You know, I don't see it half the time. I guess I would just say sometimes.
Yeah.
Yeah, I haven't seen any like statistics on that from AAA.
Sure.
I don't, yeah, and as a matter of fact, I don't think we're tracking it, right? There's nowhere that we're tracking that someone in-house or from the company came to the preliminary hearing. So yeah, just anecdotally in my limited experience, I see it probably less than half the time.
Yeah, and I would say the same. And so, but it is definitely addressed, and sometimes it's on specific cases where we think it would be beneficial. So.
All right, let's get to this last slide. I know I hope you have your glasses on, maybe zoom in to see a lot of little writing here. But from this group of surveys, there were 585 suggestions for best practice improvements. And those suggestions were grouped accordingly, as you see here. So we're just going to highlight the most frequent best practice suggestions, as well as kind of point out some others that we think are good. So the most common piece of advice, no big surprise, is to limit discovery. And so, arbitrators should feel empowered to place restrictions on discovery as they see fit to expedite that phase of the arbitration. Second to that is strictly enforcing a scheduling order. So we've talked a lot about having a scheduling order and the importance of the preliminary hearing, but then strictly enforcing it. And so I mentioned earlier in the presentation about including some language in the order that says, these deadlines will be strictly enforced and only extended for good cause by permission of the arbitrator. And then the third item there says counsel cooperation. So that's the third most frequent best practice suggestion. Encourage cooperation among the parties' counsel. Because in the earlier slides, we saw that is one of the top factors in escalating time and cost. So, arbitrators should foster collegiality and good faith in the arbitration to help alleviate those issues. Some other best practices that I want to highlight from the list here: utilize phone and email to solve issues. So we're in arbitration. It doesn't have to be a formal motion. We see a lot of case communication just occurring by email. And so sometimes disputes and issues can be resolved simply by email exchange with the arbitrator, or the arbitrator may say, let's jump on a phone call and let's try to resolve it telephonically. We talked a lot about using one instead of 3 arbitrators, so that's a suggestion. The remote testimony is was ranking further down the list. However, these results again are coming from that 2015 to 2018 time period. I think this is, Charles, where we'd see the needle moved a bit post-COVID, that you would see more arbitrators recommending remote testimony, allowing remote testimony as a way to save time and cost. And then finally, the use of digital documents and exhibits, electronic exhibits, in lieu of hard copies. So that's an area where we've gotten a lot of feedback that time and cost can be saved significantly if arbitrators will be comfortable accepting electronic documents and exhibits and managing those and not requiring all of the hard copies. Charles, I know you had some additional.
I think the one I'd add is don't forget about mediation. Mediation is obviously an option. We want to utilize that as the best we can to get the dispute resolved as quickly as possible. We offer it throughout the life of the case, and at the preliminary hearing, we obviously it's built into our rules, but also we set deadlines by which the party should have at least discussed mediation by a certain date. So.
Yeah, you'll see that in the arbitrator scheduling orders quite a bit. So that's another thing for the
That's-
arbitrators on this call. Yeah.
And then for any arbitrators out here that may be listening in, I think, you know, we want the arbitrator to not be the cause of any delays as well, right? We want responsiveness and to jump on top of these issues as quickly as possible, obviously from the front, not from a reactive standpoint. So, and parties getting along obviously would be helpful. So there's a lot of them here. Like Linda said, you got to put your glasses on, but the 2 big lines or the 3 big lines up front, they're not a surprise.
So one question that came in, which was with respect to the motions, and you mentioned it early on that you were seeing people put it in the clause, right? You can have motions. Has the AAA added anything to its clause builder? I admit I haven't looked at it lately, but I don't recall that being one of the steps in the clause builder.
Yeah, I think you're right. I would have to look to see like if that was specific. I know discovery is motions. I don't think so, but I could be wrong.
Might
No, I
be
don't
something
think-
to add.
Yeah.
Yeah, and maybe it's a good idea.
Yeah, something to add. I don't see any other questions through chat or the Q&A. I'll give everyone a second. I don't see anything popping in here. So I want to thank you guys so much for spending the time, putting all this data together for us and sharing it with, we have arbitrators and advocates in the room. And so very excited that you spent the time for us. So thank you very, very much.
Thank
Thank
you for
you.
having us.
And we will now transition to our last panel of the day, which is directed to arbitrators. Lend me your ears. We have some litigator feedback coming your way. The program is going to be led by John Jett, who is a partner at Kilpatrick Townsend. John represents plaintiffs and defendants in commercial and intellectual property litigation between in front of state and federal courts, as well as in arbitration. He works with clients operating at the intersection of 2 or more of the technology, financial, telecommunications, franchising, and entertainment industries. And then Alex, I'm probably gonna say your last name wrong. How do you say it?
Iraq.
Parak. Alex Parak, who's a partner at Alston and Bird. Alex represents clients in multiple industry sectors, including the payment processing, transportation, and pharmaceutical industries. And she's in courts and arbitration all across the country. She also does officer and director disputes and shareholder disputes. And we have Randy Hafer, also a partner at Kilpatrick Townsend. Throughout his entire 39-year career, Randy Hafer has focused his practice exclusively on issues related to construction, which of course lends himself to being in arbitration. He's been involved in matters all over the United States and internationally on a wide variety of construction projects, including power plants, solar, waste to energy, mass transit systems, tunnels, wastewater treatment plants, airports, mining facilities, and so forth. He works directly with construction participants in ADR. And then we have my partner, Holly Hempel. Holly is a partner here at Nelson Mullins. She practices nationally manages civil litigation across the United States. She represents corporations in wrongful death and other claims, including accommodation and travel-related liability, premises, and product liability. She also advises corporations related to matters related to employment, independent contractor, food safety, asbestos, and toxic tort issues, and as well as some business litigation. So we're very much looking forward to hearing from y'all. Thank you so much for being here. And I'll turn it over to John.
We do not have John online.
Have John on the line. So Alex, do you want to pop in here? Do you mind?
Yes.
Okay.
Yeah,
Great.
no, mind at all. So I connected with John before we were getting ready to do this panel. And one of the things that we kind of joked about is the panel seems to have like the topic seems to lend itself to like complaining, right? Like here we are, arbitrators, lend us your ears, let us get complaints off our chest. So I think one of the things we wanted to both caveat from the beginning is we love arbitration. All of us really enjoy using arbitration because of many of the efficiencies and other just benefits from avoiding a courtroom that we've talked about it so far in the panels today. And so let's just be clear at the outset that you know, all of this is said with an understanding that, you know, we really enjoy using arbitration, and we think it really has advantages. And these are just some ideas and experiences we've had for y'all's consideration that might allow it to be, handled more efficiently, or just, a different approach going forward. And so I think this a good topic to potentially start with is one of the things that I can piggyback off what Linda was just talking about, which is this concept of the preliminary hearing and the scheduling order. One of the experiences that I've had recently is having cases where our arbitration was set to be expedited by contract, and then struggling to find a way to flag that so that it actually became expedited before we got to the preliminary hearing and the arbitrator appointment. And so thinking about ways to maybe create an opportunity to identify early that the contract calls for an expedited process, such that the scheduling of the preliminary hearing, the appointment of the arbitrator, et cetera, might happen on a more expedited basis than would traditionally happen, for example, under the AAA rules. And Holly, I don't know if that's something you've also experienced and you would agree with, but if there was some sort of mechanism to maybe flag that this be given a little bit of a faster track on the front end, so we don't lose that time.
Yeah, I think that's a great point. And the other item that John and I had talked about when talking about the preliminary conferences is, what does an ideal one look like to us or to me? And I think it's largely what we've talked about today as far as being really organized and having the checklist. But ideally, the best case scenario for me would be that we've worked with the other side and we come to the preliminary conference with a plan in place, and the arbitrator and the case manager are so happy that we've already agreed on a lot of things. So that to me is huge. The other big point for me is to walk away with no questions, and essentially you've got a roadmap filled out with what the process is going to be. You have status conferences maybe scheduled periodically if they're needed, and if they're not needed. One of the things that we can talk about later, but that I always try and address in the preliminary conference is whether there should be dispositive motions that would streamline the case. So those are the kinds of things that I think need to be addressed in the preliminary conference that can make it just a really good process. And then we can all report back to our clients, what to expect, and there shouldn't be very many surprises. And part of that is what you said, Alex, about whether or not it's expedited straight from the start.
And hey, Alex, and hey, Holly, it's John. I'm here at last. I guess everyone now knows why I would want Alex and Holly to be on a panel. You can't find anybody more unflappable than those two, as when I invite them and then don't show up. But I was actually here. I'm visiting another office in my firm, and I was going to try to be very fancy and take this from a conference room, and that's what you get when you try to be fancy. So. Anyway, well, here I am, and we've jumped into it. I don't know if Randy has been able to get on. He was going to call in. Randy, are you there? Well, I think we'll press on without Randy, and he'll join us as soon as he can. And really appreciate Alex and Holly for getting started. One of the places that we were going to start was with the goals of arbitration. Obviously, we all see situations where one party will really want arbitration and maybe one party doesn't. It's the whole motion to compel arbitration practice that unfolds so often. And Alex, I don't know if you could speak to a little bit to when you or your clients, when clients come to you, what are some of the what is maybe the primary reason that you find yourself wanting to be in arbitration?
Sure. So what I found, and we've really had experiences that have gone both ways, where the client's chosen to enforce an arbitration provision and another where they've chosen not to, and really fairly identical situations, identical contracts, I should say, but different situations. One of the primary drivers that I see is confidentiality. and to the extent to which the client does not want it, want the matter in open court. And relatedly, the extent to which they want that confidentiality to roll over into precedent-setting decisions, and whether they want this to be handled, confidentially between the two parties, such that it doesn't have a precedential effect going forward. So where there's sensitivity to those issues, we see a stronger drive to push for arbitration.
Yeah, that's something I see also. Holly, what's the flip side of that? I mean, when a client comes to you and just is very against being in arbitration, what would you say is typically the motivation for that approach?
Usually it's something that we think we could have, that would have to be filed in small claims court, which is rare. But those are the instances in which we usually contract around that. So we say if the case is under the state court value of Delaware or small claims court, then it goes to court. If it's beyond that, then it goes to arbitration. But sometimes there's a case that, is maybe a very small case that they would rather just take to court rather than mediate, because they think we'll resolve in a settlement. But most of the time, the biggest driver for us for wanting to mediate, and because this is largely wrongful death cases, is just the lack of a jury trial. So they feel very strongly that they would rather have their fate decided by an arbitrator than a jury, especially in this post-COVID, escalating verdict stage of, our careers that we're in.
Yeah. And one of the considerations that Randy and I talked about in preparing for today, Randy was explaining that in his practice, which will often focus on very large construction projects that are often ongoing, there's a dispute, but the project is still happening. The parties still have to work together, a general contractor, a subcontractor, that there's often a desire to get into arbitration for the speed and to just have certainty, just to know, even he was explaining, even if it's an adverse result, even if one side has to pay when they maybe feel like they shouldn't, or has to pay more than they feel like they should, that having that sort of certainty and clearing the air can be immensely important in those kind of situations. And the arbitration is a much better fit for that sort of situation than would be a court case. Switching gears to a little bit of a different subject, I think this ties into some of the things that have been discussed over the course of the day today. When we think about the selection of an arbitrator, Holly, what makes in your mind for the best arbitrators that you come across in your cases?
Yeah, there are a handful of attributes that I think are most important. Some of them are, to me, are just across the board for any arbitrator, but then some of them are very case specific. So I think the ones that are across the board for me would be an arbitrator that is, completely committed to the case and has time to take on the case and is fully prepared. And you can tell that usually from the first meeting all the way through dispositive motions or any kind of discovery dispute and through the hearing itself. So just having someone who can take time and actually be present and committed, that's huge. Willingness to hear dispositive motions is actually a really huge factor for me, because so many times there are limitation damages provisions in our contracts, and that guides the litigation very largely either towards settlement or, we realize that we should fight the case on the defense side. So having an arbitrator that is willing to hear dispositive motions and either narrow the issues or fully dispose of the case is a really large issue for us. And I've had cases recently where the arbitrator has committed to make rulings within 10 days of our final pleadings. And that's huge for my clients to know that they're going to, quickly go through the case. The other thing that I really enjoy and admire in an arbitrator is when they send signals of what the ruling is going to be by the questions they ask or by pointed guidance on requests for additional briefing. It's very clear, it gives me talking points for my clients to say this is likely what's going to happen and here's why. And then it can either lead us to a resolution, or we know that we're in good in good stead to continue on. And then the last thing that's really important to me, and I think it takes some due diligence, but it's great to have resources to be able to do this, is to look at the reputation and the philosophy of the individual arbitrator. And to me, that's very case specific and it's very different from my cases. So if it's a wrongful death case where the plaintiff or the decedent spouse has signed our terms and conditions, I want the most strict reader of a contract that I can find, someone who's really going to enforce what the contract says, because they're well written and they're upheld under the law and they're based on, the exact law. So if we have someone who can do that, that's a great fit for my side of the case. On my commercial cases, on the other hand, I think a little bit differently, because sometimes it's someone who's going to look at this and say what's commercially reasonable and where, what's the right thing in this case based on the situation in which these parties found themselves. So that's case specific, but it takes some work, and it's great to have, resources in other offices and to ask folks about the reputation and due diligence, online and by asking around. I think that's the most case specific issue, but it's a huge qualifier in my mind of what makes a good arbitrator.
Alex, how about you? Sort of similar question. What makes for the great arbitrator, and maybe what makes for the not greatest arbitrator? What sort of qualities or characteristics are you looking for, or maybe looking to avoid?
Yeah, I will, of course, agree with a lot of what Holly said. I think one other thing, and it's maybe the flip side, two sides of the same coin, which is the ability to make hard decisions. So and that takes due diligence up front. It's hard to know, by reading someone's bio necessarily, will they make hard calls? And that can be especially relating to early evidentiary issues with discovery, and also whether or not to allow dispositive motions and ruling on dispositive motions. We frequently want arbitrators who will do that and who will make the tough decisions, and conversely try to avoid those who take, sort of the age-old view of arbitration is like everything gets in and it's, loosey-goosey, and it's, everybody gets to kind of proceed uninterrupted up to the hearing. And that all sounds great and freeing, but really we're all better confined by some rules and structure and hard decisions and some exclusion of things, so that we're not kind of defeating the entire purpose of arbitration to begin with, where we've, expanded the scope unnecessarily and so broadly that, we're at a much larger hearing than we really even needed.
And Randy, how about you? Obviously, your practice, is not just domestic, but you also have an extensive international practice. Are there qualities that you've seen that make particular arbitrators stand out for good or for ill?
Yeah, first, can you hear me?
Yeah, we can hear you. We got you.
Good, because I'm having to do audio by my phone. I've had internet problems today all day long. Murphy's Law, I guess. Anyway, yeah, I think one thing I would say at the outset is that, as you look at the touted benefits of arbitration, we can debate a lot of them. Is arbitration cheaper than litigation? Maybe not in today's world, especially if there's full-blown discovery and you're paying the hourly rate of 3 very prominent arbitrators, that kind of thing. Is it faster? In most cases, probably so. There are other touted advantages. In my mind, the biggest one, and maybe it's logical since I'm so specialized, is that you get your case decided by 3 people that know your industry and know your business. And I don't just mean they're in it. They know the nuances. If I'm in a construction case talking about, for instance, a limitation of liability provision and how important that is in this case, someone who knows construction will understand that the contractor, came up with its bid, its schedule, and its agreement to do the project based at least in large part on limiting its liability. So I want the arbitrators to understand those nuances. So very important to me, John, in selecting arbitrators, that they understand construction. That's where I'm always coming from. And it's gotten to the point where really you want them not only to be, generally knowledgeable of construction, but also the particular subject matter, whether it's a power plant, a metro system, an airport, whatever. It really helps if they have that kind of knowledge.
Yeah, that's great. Holly or Alex, I don't know if either of you want to jump in, but do you have thoughts on having that particular background in an arbitrator, having expertise in partnership disputes or securities or franchising? You see certain requirements in some arbitration agreements around those kinds of backgrounds, or what about a judge even, including a judge on your panel? How important are those sorts of qualifications when you're thinking about the arbitrator that you want or do not want in your arbitration?
I'm happy to go ahead. So I think kind of taking the first part of your question first, I think it depends. It's like the real lawyer answer, right? Maybe. But it just depends on the arena that I'm in. So if it is a highly specialized area, like healthcare, I think would be a good example, or we're dealing with pharmaceutical or provider or clients, we typically want arbitrators or an arbitrator. In those cases are often a panel that have experience in the industry, and then particularly with payer provider disputes, we'll look carefully at what side that experience has been on and where they've come down. But in other situations where it's contractually based, and then of course in a certain industry, but it's really a question of contract interpretation, I care more about like what Holly was saying, which is kind of the lens through which they view the world and their philosophy, than I do necessarily that they have experience with that particular type of agreement. And then just real quick on the second part of your question about, is it important that there be a judge, or how much does that weigh in? I always like seeing a judge. To me, that I think especially in a more a general situation where I know it gives me comfort that this person has had experience jumping from issue to issue, specialty to specialty, and been able to get up to speed quickly, kind of regardless of the specialized field that they're dealing with. And then of course, you can kind of, there seems to be more due diligence that you can get with the judge, and so get a little bit more feedback going in, and confirmation of the ability to kind of control the parties and run a tight ship. That's what I'm looking for. And then particularly with the panel, kind of trust that someone with that kind of experience could be the chair. So it can be a good thing and an attractive thing. I wouldn't put it as a requirement, but it's something that I like to see with the right feedback.
Yeah, and I'll jump in and say that the times that I have gravitated toward picking a judge as my number one person when I'm, picking strikes, is when I really can't find much about the other arbitrators and I'm really shooting in the dark. And I think there's some confidence level that the judge will make decisions quickly and will stay with the flow of, our goal of an efficient and fast arbitration. But also on the subject matter, I find it important in certain cases. So my maritime cases, I think, are really important because there are certain issues that, are very novel. Does the Athens Convention limitation of liability apply to XYZ, or, how does the Death in the High Seas Act apply? And so having someone with maritime experience in those cases is really helpful. But I go back to what Alex said, most of the time it's contract interpretation for me. And so the philosophy and reputation is a lot more important than the subject matter expertise.
Yeah. So at the very outset, we touched a little bit on expedited arbitration, and that's such an important issue, and often something that I hear from the clients, that the timing will be sort of foremost in their mind. I know we heard a little bit from Alex on it. Randy, do you want to share anything about your thoughts on expedited arbitrations, or sort of maybe efficiency that you have seen and learned about in your international arbitration practice?
Well, that could open the door to a lot of comments, but maybe let me come at it this way. I'll have to admit going in that I don't do a lot of expedited arbitrations. I think, as I heard Linda or someone mention during the previous program, construction cases often involve multiple parties, and they're usually not suited unless it's a very small matter to the true expedited process the AAA has. But as far as otherwise, in a more general sense, expediting things, and maybe to touch on another topic, and that's preliminary motions. In international arbitration, preliminary issues. And I know there's a lot of debate about the usefulness of such procedures. I would say, number one, if there are such issues in your case, you got to get them in front of the arbitrators immediately, so that everybody knows going in that you and your client intend to bring that type of an issue at an early stage in the process. It seems to me, and then again, I'm speaking from my background, almost every contract I deal with nowadays has a variety of limitation of liability provisions, whether it be a mutual waiver of consequential damages, an overall cap on aggregate liability, even what I call internal statutes of limitation. In other words, an agreement between the parties that if they're going to have a claim against the other, it has to be done within a certain period of time or it's waived. All those things I've seen come into play almost constantly recently in my cases. So, if I have a client who's would like to enforce one of those provisions, they've had a demand for arbitration submitted. It exceeds the aggregate liability everybody agreed to. It contains consequential damages, and it was outside the limit everybody agreed to. They're looking at me and saying, what am I doing here? Do I have to be dragged through this process when the opposition agreed to all these? They wouldn't do this. And so those are usually the subject of a preliminary issue. You don't always get an answer. Arbitrators frequently say, we'll take it under advisement. Let's hear all the evidence. But I have very often in recent days gotten a ruling before the end of the arbitration. In other words, after some discovery's been done, maybe after a few days of the hearing, and the arbitrators have on their own said, let's go back and address that issue. So to wrap that up, I would say under the heading of, making things more efficient, expeditious, and so forth, if you have those sorts of issues, get them on the table. Even if you don't think you'll get an immediate ruling, get them on the table and move forward.
Yeah, I can jump in on that and say that I've had really good success with these preliminary motions. And it's usually been in the same concept that Randy's talking about related to the limitation of damages. And the way we've handled it is to bring it up at the preliminary conference and sell it immediately, that it is going to streamline the case if these are ruled on. And we use it as a reason to either bifurcate or trifurcate discovery. And so it sets it up that you have to have an order before you can move on to the next phase of the litigation. And, we sell that by the efficiency that it brings to the process. And we've had really good success in that. And it usually leads to a resolution of the case if the damages caps and things are put into place, because then it makes sense for everyone to come to the table and mediate. So we do, to Randy's point, I think the key is to raise your intentions very early, let it be known that you plan to do this almost as if it's going to happen, but you do that by selling that you really have a good chance of success, which is really the test of whether or not you're allowed to file these. And then how that will streamline the litigation.
Alex, I know you touched on it a little bit. I don't know if you have anything you wanted to add about early briefing as a way to move things along in arbitration.
Yeah, no, I completely agree that where it's appropriate, it can really help. And I think relatedly, we kind of talked about the back end of it, dispositive motions and whether those streamline things or slow things down. And I think to try to preview up front your position on whether this is a case that, is really worthwhile for this or not, such that the procedure built in isn't a waste of time and isn't dragging it down and isn't a case for further delay, and really is a time and an opportunity to present a real chance to streamline issues, cut issues, get the parties to the table to reach a settlement. I think that it's important. So I think previewing those things is helpful. And probably the sooner you do it, the better. I haven't had much experience where I've previewed it and it not resulted in an opportunity to file a dispositive motion on the issue. And so, thinking about it backward looking, perhaps that's part of why is the early preview. And, I think that the other benefit of previewing the issues early, whether it's something as straightforward as a limitation of liability issue, or maybe something a little more complex, like the potential need for bifurcation. Even if you don't win, you've given the arbitrators a chance to understand and appreciate part of your story and your theory and how you're going to present your case and why upfront and early, which I think is always helpful as you're trying to educate three folks who are not nearly, or one, nearly as close to it as you are.
Yeah.
So I think trying to use the preliminary conference as much as you can for more than just let's enter some dates. And some arbitrators are more willing to engage in substance than others. But I think also if you have folks who aren't as willing at the preliminary conference to engage in anything substantive, to try to table or pencil in a time where then you can raise those things early.
Yeah. And so Holly and Randy, sort of embedded in Alex's comment just now is the possibility that you could file early motions and I don't know, I mean, even I guess they could, I think Randy, you said sometimes you see the arbitrators hold on to them for a while and grant them in the course of a final hearing. But what is everyone's experience in terms of whether these early motions are being granted? I mean, is there value in, is the real value in educating the arbitrator, or are you seeing these as effective tools to cut off a case much earlier? I mean, not just maybe the damages portion, but I mean, are you seeing entire cases disposed of through early dispositive motions? What are you seeing sort of on the ground?
I'll jump in first. My most recent experience was in an ICC arbitration where we filed it up front, just like Holly said, got it on the table. The arbitrators established a briefing schedule. We did that. They ruled that they would take it under advisement, but needed to hear additional evidence. So we moved forward with the hearings. Now, I will point out in international arbitration, where you don't have near the discovery you do in domestic arbitration, you get to the hearings a lot quicker. And so, it's a different analysis there with regard to time and cost. But any event, we then go to the hearings. We start moving through witnesses, sort of the typical process of fact witnesses that were going to be followed by experts. And at some point, we felt like, whatever facts related to our motion had come out in testimony. And so we renewed the motion, at which point the arbitrators turned to the other side and said, we're inclined to take it under advisement again. Do you have any other witnesses that you want to call on the subject of that motion, and it was limitation of damages. And the other side caucused and came back and said, yeah, there's 3 more people, so we heard 3 more witnesses. Arbitrators said again, have you now put in everything you want to put in on that preliminary issue? And they finally said yes, at which point the arbitrators adjourned the hearings, I would say probably halfway through the process, asked again for final briefing, and then they made a ruling, which in that case granted our original motion and completely disposed of the case. They also, which I think is appropriate, awarded costs and attorney's fees to us because, you know, essentially we had a defense to ever having the arbitration. Our client had to spend a lot of money to get to the final result. So they flipped those costs back on the other side. That's one recent experience. I will say just me, most of the time, at some point, those provisions get enforced, even if it's in the final award.
Yeah. I always have the concern, Randy, about possible vacatur if an early motion is granted and the other side didn't have an opportunity to put in evidence. So that's interesting how that unfolded in your case, allowing them all the opportunities to put in the evidence. Holly, what do you think?
Yeah, I've had experiences where the judge has just ruled based on the pleadings because they find it's a pure issue of law, and they've invited additional pleadings on various topics, maybe on whether a certain provision applies of international law or something that would strike the law that we are arguing applies. And I've had judges allow limited discovery as well, but mostly mine have been granted. And most recently we had one granted very quickly. It was a limitation to the amount that someone had paid for a trip versus, a wrongful death action where they could proceed and try and obtain much more. And so as we knew that if that was granted, the case, we shouldn't have to have fact discovery. We shouldn't have to have a lot of different things. And so there really wasn't much to decide other than the legal issues. So the judge did that really quickly, and then we were able to resolve the case. So I think it depends on the nature of the case and how much discovery is necessary. I would suggest that if the arbitrators are just deciding based on a purely legal issue, that should be done quickly. If it is something that involves discovery, phase 2 would be limited discovery on the issue, allowing a ruling on that dispositive motion, or at least issues on the, that could be dispositively eliminated. But it seems that you shouldn't have to go through an entire arbitration hearing to get to that point.
Yeah. Alex, I don't know if you have anything more you want to say on that, or if we should sort of.
In my experience, it's been kind of what you were indicating, John, which is a little bit more, we see reservation for addressing the motions up front because of the concern about, that's the grounds for review. And so typically we're given the freedom nevertheless to go through the discovery process, and then the motions are accepted afterwards. They're basically not invited, or the scheduling order doesn't usually give an opportunity to do so until discovery is completed. So that's how I mentioned, we preview it up front and that this is coming, but rarely does it result in an early motion. It's much more the typical dispositive motion following discovery. Those get ruled on in sort of the traditional course, and oftentimes the scheduling order promises a ruling within a certain period of time. So it's not been my experience where they sort of languish out there. It's something that we filed early and never gets addressed. But my experience has been more reservation about accepting them early. And so that's something that I think, having, again, one of the things I mentioned at the beginning of things that I find appealing about certain arbitrators is the ability to, maybe make a hard call. And I think, with the goal of arbitration being to be more efficient and reach a resolution early, it is appealing to have an arbitrator say, look, I'm going to interpret this purely contractual question up front, which might dispose of substantial discovery, on an irrelevant issue, but I just more frequently find a little bit of reservation in doing so. And so we end up sort of with more expansive discovery than we might have needed in a back end ruling.
Yeah. Holly, when we were getting ready for today, one of the points you made was about how the briefing process can be made more effective in your experience through some questions. Sometimes when an arbitrator, takes the time to help direct the parties. Do you want to speak a little bit about your experience there?
Yeah, I think it really shows that the mediators are paying attention because, especially if there are page limits on what you're originally filing, you're trying to jam 6 really important issues into, 15 pages. And so asking for additional briefing on key issues is important, I think, for both sides. I also think it sends an important message that we can take back to our clients about, like, as we anticipated, this is a key issue and the judge or the arbitrator has honed in on this and we need to really, work our best at this, and it's a make or break issue for our case. So perhaps while this is pending, this is another opportunity to look at resolving the case. So I invite that when that happens, and I see that whether we have a case that the mediator has expertise or not. Sometimes they just are seeking, guided briefing on very specific, minute issues that are really interesting and fact specific sometimes, and the application to the facts and the law. So I really enjoy that, and I think it's, I wish judges did it more as well. So I think it's a benefit of arbitration.
Yeah. Alex or Randy, anything you want to add about approaches that arbitrators have taken that have made the briefing process more efficient? Because I'll say that I might have been, if I'd been a 4th panelist here, I sometimes have some reservations about a lot of early briefing or about multiple rounds of briefing, just from an expense point of view, especially if we don't have, as Holly is saying, direction from the arbitrator about what is particularly important to him or her or the panel. That sometimes it feels like we're casting about and spending a lot of money and maybe not advancing the process. Not in every case, but I can think of examples where it felt like we maybe weren't being efficient through multiple rounds of briefing. So I think Holly's idea about sort of direct questions is really good and something that I'd maybe try to explore in an upcoming arbitration. Randy or Alex, anything that's efficient around efficient or effective around the briefing process?
I think the most effective tools I've seen are just strict limits, in scheduling orders and what's provided and what's allowed and what you might have to seek, request to actually, an additional, like a letter request, for example, so that the arbitrator can make an initial call of, is this really worthwhile? Am I going to allow this? Give me a preview of what's coming. And I guess this kind of piggybacks on Holly's point of like getting a preview, right? So you reach out and you submit your letter request of the issue you're going to raise. The other side gets a very brief response, so you're not expending substantial resources, and the arbitrator lets you know early, okay, I'm willing to hear this is worthwhile, or no, let's not raise this now. So I do think, and we see that a lot around dispositive motions too, and I'm a big fan of them for dispositive motions as well, because in cases where we don't have like a limitation of liability or an obvious kind of easy, summary judgment type argument, you can see how it devolves quickly into like being in state or federal court, where we throw the kitchen sink in the summary judgment motion and we try for like every factual issue we might be able to resolve. And it's just so unlikely to be successful in an arbitration. And so even having those, kind of previewed letter motions where you're requesting the dispositive motion, so you could solicit, to Holly's point, some direction about what might be allowed and what might not be allowed. So I just think tight parameters, having to ask permission in certain cases, and tight page limits are always good too.
Randy, do you have a preference for pre-hearing or post-hearing briefing? I guess just imagine maybe a situation where an arbitrator or panel would only allow you one or the other. Which do you favor?
That's a tough call, and it probably varies case to case. A little bit related. I always advise people never give up the right and argue for it if the arbitrators seem to be against it, to do some sort of an opening statement. I always feel like that's very valuable. Of course, it's even more valuable if you've not done a pre-hearing brief. I find that in most of my cases, whether the parties would want to do one or not, the arbitrators ask for them because you're talking about, in my cases, the subject matter, the project may have spanned a 3 to 5, in some cases 10-year history with documents and witnesses and issues, and to have that succinctly summarized before the hearing, where you tell your story and direct the arbitrators to the issues that are critical in your view, is very important. That said, I agree with Alex's point that you gotta rein things in. I mean, I know we've all been in the position where somebody told us, you got to write this in 10 pages. And initially we panic. When we finally churn it out, a lot of times we look back and say, wow, that's pretty darn good, And I do think we as lawyers, whether it's discovery, brief writing, asking that one last question, whatever it is, we tend to go a little too far a lot of times when we could make our point much more succinctly.
Alex or Holly, forced to make a choice, pre-hearing or post-hearing briefing.
That is a really, yeah. I mean, to Randy's point, like, it's hard to not have that last word, right? So you feel you're like inclined to read it. Yeah, but I think you're probably better sort of framing up the issues in advance. But that's a really tough call. I do like Randy's point, and John, you and I talked about this when we were chatting about this panel, which is just the need for being, and how much I think we all sort of subconsciously crave arbitrators who will rein us in and put tight restrictions, because we're trying to zealously advocate for our clients, and so we want to get it all in there. And sometimes it's better to have the rules in place that require you to leave some stuff on the cutting room floor for efficiency's sake and for presentation of the evidence. And so I really do prefer arbitrators who control the hearing, including the pre-hearing and the post-hearing briefing, in a way that has those limitations in it. Even though sometimes during the process I might resent it, but after the fact, I know it's always a good thing.
I vote for pre-briefing, and the only reason that I would want to do post-briefing is if I was asking for a reasoned order, which I typically do not do. My clients prefer not to have a well-reasoned order. So I feel like the post-briefing is a great way for the arbitrators to lift out parts of those arguments and put it into the order. But if you don't need that, then I don't see much benefit in the post-briefing pleadings.
Turning now a little bit to discovery, which we saw in the last presentation, one of the primary considerations for everyone in going into arbitration. What are the features of an arbitrator or a panel that is optimizing discovery in arbitration? I mean, where is that balance between the cost efficiencies and the speed of arbitration, and also allowing people to develop their case and put in adequate evidence and to sort of have a sufficient due process in arbitration? Where's that balance in you all's experiences? Alex, can we start with you on that?
Yeah, I'm probably going to sound like a broken record, but I think it's sort of in that setting of upfront limits. So hearing the parties upfront about their views on the case, and you might have two very differing views in terms of expanse and scope, but then taking those perspectives, not being afraid to make the hard decision and setting the parameter of this is what will be allowed, and then enforcing it. And I think it was the last panel, perhaps Linda, talking about when you have the scheduling order in place and provisions that say, this will not be modified absent, real reason, and you have to petition for the arbitrator for any modifications, et cetera, so that it's not viewed as kind of guidance that you follow and then you can keep going back and requesting changes. And it's more, these parameters are in place for a reason, given the careful discussion at the beginning, and they won't be modified absent real reason to do so. I find that's the best balance. It usually is somewhere in the middle. Usually have one party that wants to go a little bit more deep, another party that wants a little more confined. And so that tends to work so long as it's enforced.
Holly, how about you? What does the best discovery and arbitration look like, the best framework?
I like rules. I like the narrowing. I think what Randy said is really a great observation, which is that if the other side's pushing for more, you in response to that could argue, well, let's start with 3 depositions instead of 12. And if you need more, let's come back and ask for more and have to give a justified reason why you really need more. And I think to Randy's point, we all do want to get ahead and push for more because you think you might need it, but when push comes to shove, you really probably can narrow it down a lot. I also think that when people are asking for multiple depositions or things more than they need, it's probably because they're not prepared and they don't have that really good roadmap of their case to begin with to know what they really need. And so I think it's just a way for the arbitrator to control the situation and force folks to be more organized up front and to have a plan for the arbitration and a map of their case or their defense of the case. So I think that's part of the arbitrator's role, is to tame that down. But I'm also not opposed to just saying, let's just abide by the federal rules and just live by that and just agree that those are the rules, period. And we've had great success with that limitation by just agreeing to that upfront. It takes a lot of stress off the arbitrator, I think, to fight with a lot of discovery battles when we agree to that upfront.
And Randy, how about you? I know you're able to draw on your international arbitration experience, in which discovery is handled pretty differently. Have you learned any important lessons from that? Things you'd like to, maybe you prefer domestic arbitration now, having not had that discovery? How have you come out of those experiences with the international arbitration?
Yeah, it's definitely a different world when it comes to discovery. I would say, though, first of all, and maybe our AAA friends could confirm this, but a number of years ago, there was maybe too harsh a word, uprising over arbitration becoming too much like litigation. And it resulted in a lot of committees being formed and studies being done. And we had I forget the formal name for it, but protocols were issued by a committee and a group that was formed to deal with commercial arbitration. And it all centered around a complaint that had really built up some steam, that arbitration was never intended to be the same as litigation. And the focus of that complaint was largely on the discovery, where it had become very much like being in court. I find today, at least in the arbitrators we get are from the construction panel for the most part. They seem to be sensitive to that issue, that arbitration is supposed to be different, more efficient, more reasonable in terms of time and price. quickly, I'll say, yeah, in international arbitration, for those of you who aren't familiar with it, it starts essentially with the premise that there is no discovery, that each side should come into the process with whatever information they need to make their case. I've never had an international arbitration where there were ever any depositions, so that's never part of discovery. We will have discovery, document discovery, and other information, but it has to be extremely focused. And you have to show, if you're after some documents, you have to define them in terms of, you know, let's say time and description and so forth, and show that they're going to be critical to your case. And if you can show all that, maybe the arbitrators will order the other side to give you those documents. I will tell you, and you know, when my first one, I was like, you got to be kidding me. You know, I can't get all the documents. I can't take anybody's deposition, not even an expert. You know, this is crazy. But I will tell you, I'm converted. I mean, I've gotten to the point where I like the process. I mean, it streamlines things. I've never felt like, in fact, I had one client say it's great because the fact is, you know, the turn over every stone approach, it ends up 90% of what you get out from under those stones is never used. You know, you end up with whatever you guys call them, your key document file or whatever, and that's what your exhibits become. And it can be any, you know, as low as 10% of what all the discovery was about. And I know finding those documents is easier said than done, but I find clients like the restricted approach, and I've come to accept it and actually prefer it over what I'd call full-blown court discovery.
As we turn to maybe a final topic to talk about together, we've done a good job. We've gotten through this entire presentation. We haven't talked about the pandemic or about COVID, but one of the things that came out of the last couple of years was the virtual deposition, the virtual hearing, you know, taking witnesses who would otherwise be unavailable, having them testify, maybe at a hybrid deposition, or excuse me, a hybrid testimony at the hearing where the hearing's being held live, but you have some witnesses participate virtually. And I think everyone on our panel and myself have done virtual or fully virtual arbitrations during the pandemic. Where are you all now? I mean, where are your preferences? How do you see the future? Would you be amenable to fully virtual final hearings in the future? Would you track more towards hybrid, a mix of in-person and virtual? Or are you looking forward to the days when you won't have any more virtual testimony? So where are people falling on that? Alex, could we start with you?
Yeah, sure. So I think my answer is a little bit of a hybrid, which is I look forward to the days of no virtual and testimony or hearings or anything, but I think the reality is that I probably need to accept that there will be some hybrid approach going forward for a long time. That's not my favorite. I don't think the presentation of evidence is as effective virtually, but I think that there are some accommodations that can be made with certain witnesses that would allow their inclusion in a hearing and allow the hearing to proceed more efficiently. And we might see and have clients prefer to accommodate those witnesses with virtual testimony and virtual depositions and the like, you know, different time zones or far travel, et cetera. But I hope that it remains more the exception as an accommodation than it is sort of the traditional rule going forward.
Holly, what do you think?
Yeah, I echo exactly what Alex said. I think that the hybrid is where I lean, and that it's more of an exception or stipulation by the parties if they perceive that it'll make the arbitration hearing more streamlined. And I agree that, you know, my experiences, some of my, like my corporate witness, for example, is usually somewhere international. And so that would make just scheduling and planning much easier. So I think that there's definitely room for a hybrid scenario, but I think I heard earlier that the AAA is leaning towards or already 100% back with the idea of it being in person. So I definitely like that concept for the presentation of evidence and at least the attorneys and the key witnesses being present. So I think a hybrid is the way to go going forward.
And Randy, I think you said you had pretty good experiences with virtual. So what do you think?
Well, I did. I had a 4-week virtual arbitration recently. All 3 arbitrators were in different places. We were in Atlanta. The opposition was in Montreal. The witnesses were all over the world. And it actually worked surprisingly well, despite my own technical issues today. These court reporting firms that have sort of, quickly adapted to virtual and have platforms for exhibits, for everything. And they basically, you hire them and they run the whole process. And I found it to work very well. Our client, who's really, in the end, the most important decision maker on whether it should be, if we have the choice, virtual or in person, was adamantly opposed to it at the outset. The client felt like you can't really effectively cross-examine a witness over a camera. But at the end of the arbitration, they were convinced that going forward, COVID or no COVID, they wanted virtual because of the tremendous savings and expenses. They don't have to fly people around. They don't have to have 2 weeks of hotel rooms and meals. And they found that, seeing a witness's face blown up on a big screen, sometimes even where the sweat is running down, was an effective way to cross-examine in the end. And so anyway, they were convinced. I go with Holly and Alex. I think it depends on the case, but there'll be times when it's very efficient to do a witness remotely, but also it's always good to get everybody in that same room.
Yeah. Okay. Well, this was awesome. It's great being with you all. And I think I see Erica. So I think our time has run. Erica?
Time has run. You guys this was amazing. So much insight, so much experience. Really, thank you all so much. I didn't hear a word of complaint, but it took, even as I'm an arbitrator, took a lot out of that discussion. And so I really appreciate all the time and effort that you all put in putting this program together for our audience. I want to thank everybody who joined us today, in our audience, and all of our panelists who really gave us that masterclass in arbitration. And we look forward to doing this again next year. Maybe we'll have different topics. But since we are a state bar organization, it'll probably be virtual so that we can get everybody within the state of Georgia and they don't have to schlep up to Atlanta. But we appreciate everybody today. The CL, as I mentioned before, due to the Georgia State Bar's website being down, the CLE materials were not able to be submitted until yesterday. They have been submitted. Once that CLE is approved, which you expect it to be, you will get those materials and you should see that credit. Do not start emailing Lane at the State Bar just yet about where your credit is, because it will take a little bit of time to process. But thank you all so very, very much. And we look forward to seeing you at our next program, which will be actually a good one. It's July 12th. It'll be a webinar. And we're going to have arbitrators from across the country talking about tips and tricks for litigators in arbitration, including tips for cross-examination, which a lot of us struggle with. So look forward to seeing you then. Thank you so much.
Thank you.
This concludes today's webinar. Thank you for joining. Have a great afternoon.